Motion.
Motion, Lordship.
You filed it.
Yeah, we filed it also. Tomorrow also.
What? What?
Lordship, the principal selection is going to be held, and I have not been called for the interview. There are some illegalities there. I am challenging the selection process tomorrow, Lordship. Apply is there, Lordship.
Maybe the same day, Lordship, for motion, Lordship, on Tuesday, 17th.
You filed it.
Lordship, yesterday we have.
It will come up.
May not come, Lordship, because if urgency is not necessary, the filing section says if urgency is not coming, it has to be mentioned.
Okay.
Tuesday.
My lord, I am praying for one urgent matter for listing as motion matter, Lordship, tomorrow. Matter is relating to transfer of posting, Lordship. My lord, already we have filed yesterday, Lordship. Can it be on tomorrow, Lordship?
Okay.
Made please, Your Lordship, I beg to mention item 19 with consent of the arrears, that hearing matter, Lordship, which was after vacation, Lordship, permit
19.
19
You are for the petitioner.
petitioner. Lordship.
Okay, on request made by Mr. B.P. Boral and the council.
My lord, I have also similar
One
prayer in item number
Is the
7.
matter after the
My lord, I have
winter
also,
vacation.
Yes.
Okay.
my lord, I have also similar prayer in respect of item number 17.
Yes.
After vacation.
Okay, on request made by Ashita, Learned Council for petitioner.
May I
This
please?
after the winter vacation.
Similar pair, my lord. Similar pair. I beg to mention item number 22, my lord. So matter may be taken up after the room, my lord.
Okay, on request made by Mr. A.K. Datta,
22.
Learned Council for the petitioner. List the matter in the month of January 2025.
May it please, Your Lordship,
Oh.
pray for listing of 2 writ petitions, Your Lordship, for orders in the next week, Your Lordship.
For orders.
Yes, sir. There, Lordship, there is some interim prayer which is required to be decided.
Okay. 18th.
Much obliged, Your Lordship.
May I please your lordship pray for listing to writ petitions for admission? Both are pensionary matters, my lord.
After vacation. Oh. 20 January.
Next.
May I please, Your Lordship, what you mentioned for listing an item. Can it be on 17, Lordship? I have filed.
What is the urgency involved?
Lordship, urgency is that I have filed a case on 28/11/2024, and now it is, Lordship, 12/20. That's the urgency, Lordship.
What is it?
Lordship, I filed a case on 28/11. Now it is 12 of December.
For motion.
For motion, Your Lord.
It has not come up.
No, no. Lord.
Okay.
Lordship, on 17, Lordship. God bless you.
Item 1 of daily list, withdrawal.
May please the lordship, quantum case number 1721/2018. I may be allowed to withdraw this petition.
You've complied with the order?
Yes.
Okay, MS.
K tie.
Okay.
Tie.
Learned Council appearing on behalf of Mr.
A only.
Ali. Press for withdrawal of this contempt petition.
See, in this case, I am appearing for respond number 1.
The H3 Learned Council appears for the response number 1.
And
And Mr. B. Deori, Learned Council appears for the response number 3. Contempt petition is accordingly closed.
obliged.
2. Lordship, as per party petitioner instruction, I would do the matter.
You want to withdraw?
Yeah.
You are Mr.
MH Ahmed.
Mr. M. Ahmed, Learned Council for the petitioner. Press for withdrawal of this petition. MS P. Das, Learned Standing Council appears for the Secondary Education Department. And Mr. S. Bora, Learned Standing Council appears for the SSA. The petition is dismissed and withdrawn.
3.
May I please your lordship? Here, the petitioner has already got the relief, my lord.
Your good name?
K. Burman.
MS K. Barman, Learned Council appearing on behalf of Mr. K. Patari.
Yes.
On the counsel for the petition submits that the petitioner has got the reliefs and accordingly prays for withdrawal of this petition. Stop. MSP Das, Leonard Standing Council appears for secondary
Secondary.
and MS
RM Barua for the finance department.
RM Barwa, Leonard Standing Council appears for the finance department. With petition is accordingly dismissed on withdrawal.
4,
Here also the petitioners got the relief, my lord.
Okay. Same party?
Yes,
Same order. Same order.
Deeply obliged.
5, motion.
In this matter, some time is required, my lord, and instruction is within, my lord.
Then I'll issue notice, I think.
No, my lord, let him bring instruction because I approached by way of filing contempt also. Contempt also they stated that they will provide arrear bill, my lord.
Oh,
Let
that
him
I-
bring instruction, yeah.
Okay, heard MSK Devil and council for the petition on request made by you, Sharma, and understanding council secondary education department. How much time?
Less after 2 weeks, my lord.
2 weeks time is allowed to enable him to receive instructions. List up to 2 weeks.
Highly obliged.
6, implement of party.
Wait, please, my lord. This I have filed for impleadment of respondent number 13 and 14. My lord. Principal Secretary. Principal Secretary to the Government of Assam Welfare of Boroland Department and Commissioner and Secretary of Finance Department.
Anybody appearing for the opposite parties?
My lord, I will appear for this newly respondent number 13.
Okay,
13
no,
and 5.
no, in the present,
Present 5. I'm appearing there.
huh?
Respondent number 5, my lord.
5 is commissioner and secretary
My lord.
and elementary. Okay, heard Mr.
M. Golita.
M. Kalita and the counsel for the applicant. Also heard Mr. N.J. Katania, understanding council elementary education. For the respondents 1 to 4. And Mr. Ardhar, an additional senior government advocate. For the respondent number 5. Stop. By this application, the applicant is praying for implement of within bracket A, huh? The principal to the principal secretary to the government of Assam. What is this? Welfare of Botolan Department.
Yes,
Yes,
my lord.
That's
Yes.
correct.
Yes, correct.
Welfare of Botolan Department, comma Tispur, comma Guwahati 781006 and Miss within bracket B. The Commissioner and Secretary to the Government of Assam, Department of Finance, comma Tispur, Guwahati 781006 as party respondents 13 and 14 in WBC number
WBC number 1796.
1796 oblique 2023. On the ground that the aforesaid proposed respondents are necessary parties. Stop. Para. This court has considered the cause shown in the present application and is satisfied. And accordingly, the prayer for implementation is allowed. I is disposed in the main writ petition in view of the order passed today in I number so and so. Let so and so be implemented as party respondent number 13 and 14 in the present. Para petition is directed to file an amended cause title within a period of 1 week.
Yes.
Stop. Mr. Ardhar, then it's additional senior government advocate, appears on behalf of the newly implemented respondent number 13. Are you appearing?
Here for finance department.
That principal,
Commissioner Secretary, newly implemented.
and MS
H. Barua
H. Barwa,
on behalf of Mr. P. Nayak.
Leonard Council appearing on behalf of Mr. P. Naik, Leonard Standing Council Finance appears on behalf of the newly implemented respondent number 14. Stop. Accordingly, no formal notice is required. You want to file affidavit?
Yes.
Mr. Ardhar, additional senior government advocate appearing for respondent number 13, and MS so and so, appearing for for respondent number 14. Jointly praised for how much time?
2 weeks.
2 weeks time to file the respective affidavits. Praise the Lord. List after 2 weeks.
Oblashmi.
7, admission, part-heard matter.
May kindly pass over the matter for the time being, Lord.
Okay.
Finance.
Finance, health department.
Last time also.
Lordship, Mr. B. Gogoi will appear for this matter. He's on legs in court 1 year, Lordship.
Okay.
Pass over for time being, your Lordship.
All right.
Much obliged.
8,
The last occasion kindly peruse the order dated
What are the? What are the?
18/11/2024 বলে।
এখন ফাইল হয়েছে নি তো? এখন আর কত ফাইল করতে? Order confirm.
A detailed affidavit is also supposed to be filed for it,
Okay.
but not.
We are awaiting the instructions in the detail affidavit, but the person concerned on that day, madam, the TU is.
Who's the concerned?
He's-
Shadullah Khan.
He's here, madam.
Yes.
So,
See, when you file your affidavit,
now.
yes, sir.
when you file your affidavit in this writ petition, when you were acting, when you were then the inspector of schools,
Yes,
Golpara,
Golpara.
GTC Golpara, you did not mention in your affidavit that the advertisement has been issued and appointments have been made. You knew very well at that point of time. Why did you not mention that thing in the affidavit?
Regarding advertisement, it was not officially known by the miss at the time.
How do you know that? How do you know that?
Officially, it was not known.
Because see, you filed your affidavit on 23rd of February 2023,
Yes, sir.
correct?
Yes, sir.
Advertisement was made on 1/3/2022. And selection was already completed. So obviously you would have known that the advertisement was made. You did not mention that in your affidavit.
Actually, Your Honor, your appointment was made by the undersigned against 21 number post, 16 number post against vacant 21 number post.
Yeah.
Without allotment of place of posting.
On the basis of the advertisement of 1/3/2022.
Yes.
So you knew it. You met you issued the appointment orders, correct?
Yes.
Then when do you file your affidavit on 23rd of February 2023? Why did you not mention that in your affidavit?
Yeah, actually, Your Honor, yeah, officially it was not known regarding advertisement.
I don't understand. You say you have issued the appointment orders,
It was,
and now you say that officially you are not in the knowledge.
it was advertisement was made for the whole state of Assam, or including all department.
Correct.
Yes.
Yes.
Clarify, my lord,
Yes.
what he's trying to say, what he had told me out there. The advertisement of 2022 was issued by the Director of Secondary Education on a state basis. We did not know which posts of which schools were being taken. It was not in his knowledge. Now, when the advertisement was made, the selection was made. It is done at the district level that these are the persons concerned from our district who can be appointed under that particular advertisement. So whatever selection process was there in his district, whatever paper was there, those came to him. He did not know which school posts are allotted. He made the appointment of that this person can be appointed. He issued an appointment, but the allotment of the school was done by the Director of Secondary Education. Therefore, his affidavit, he did not know that that particular advertisement contained a post in the school concerned, or that a person is being appointed or allotted to that particular school. Therefore, in his affidavit, he could not state that this post is under advertisement and that an allotment has been made to that particular.
He is the inspector of schools.
Yes, ma'am.
He's holding a responsible post.
He is.
Can he not explain that before this court now?
My lord, that
Does he need the help of a lawyer to explain that situation?
part, my lord, he is.
You can't explain your position?
Yes.
This question this court was asking you was after the advertisement of 2022, you made appointments and filled up the post. In your affidavit, which you filed on 23rd of February 2023, you did not mention that advertisements were made and appointments were made. So this court is asking you a question, why you didn't make that statement in your affidavit? And you can't explain it. You require the help of a lawyer to explain your position.
Your Honor, advertisement was made by the State Recruitment Commission, and selection was also done by the Recruitment Commission.
Who issued the appointment order?
Appointment issued by the Inspector of Schools, Golpara,
Then
without showing allotment of place of
that is
posting.
what we wanted to know.
Yes, sir.
Yes, Majumdar, what do you?
We had prepared an affidavit explaining the position, but since we were not under liberty to file it under any of the orders we have filed, otherwise the affidavit is ready, explaining his position as it is.
Okay,
What happens is, my lord, the
let him file his affidavit.
class 3 and class 4 recruitment, the selection process has been taken away to the state level. We can just tell what are the vacancies there. So therefore, that he might have escaped him. He should have explained it properly at the time. Now, my lord, the prosecutor has that opportunity to explain that part to his affidavit. The matter can be taken up for final disposal matter on any given day. By that time, I'll have my consolidated affidavit filed. I was
Okay.
awaiting instructions. Somehow it did not come.
Heard Mr. R. Islam and the counsel for the petition. Para. Mr. Shadullah Khan, who was the then inspector of schools GTC Kolpara, Assam, is present in court as directed by order dated 18/11/2024. Stop. He submits that he would like to file an affidavit explaining the position as to why in the affidavit dated 23/2/2023 he did not mention with regard to the advertisement dated 1/3/2022 and also that the selection process has been completed. The prayer is allowed. Stop. Para Mr. R. Majumdar, Learned Standing Counsel,
Department of School Education.
Department of School Education, also prays for 2 weeks. 2 weeks time to file a consolidated additional affidavit.
Addition.
Prayer is allowed. List the matter after the winter vacation. I'll list the matter after 2 weeks. In the meantime, the personal appearance of Mr. Shatullah Khan, the then Inspector of Schools, GTC Golpara, is dispensed with.
And that date may be fixed, man.
Yes, the matter.
After vacation, man.
What I would suggest is, my lord,
After the Bihu will take up.
if I, my lord,
Yes.
file my affidavit, he files a reply if he needs to be and
But
makes a mention of the matter, it can be taken up.
No, my lord. In the meanwhile, I will reply file if they will file, my lord. After vacation, you vacation, my lord.
Okay, 23rd.
Yes, much appreciated.
I'm deeply obliged.
9.
They have to produce instructions, my lord. Because the submission was made by the respondent, my lord, that school interest is in the HM. Then the lordship asked to produce the records that how he transferred from school, because although that was promoted transferred. Now, very interesting fact, my lord. Last Sunday, that principal who retired was called for. He was in a NATO school. His wife also teaches in that school. And that principal was forced to sign a document 2 years back. That is the instruction I got it, my lord. Their total manipulation, because lordship may see that the records have been produced.
You have to record.
Before making a statement by a senior advocate, my lord, at least he should verify after verification of the record and placing the records, he should make the statement.
Let him
On the basis of hearsay, my lord,
This type of statement should not be made, my lord. There is no such document in the record that the principal forced or inspector school forced the person to sign any document. There is no record like that way. In the record reveals that, my lord, the district promotion committee considered the promotion. Earlier, lordship heard that the petitioner does not have the requisite qualification for holding the post of headmaster of a high school as per the rule. So the school, the only other part is that she was promoted and transferred to the another school. The school in which the petitioner is working was provincialized in the year 2013, my lord. And for promotion as per rule, my lord, 10 years continuous service in the graduate scale is required. The petitioner does not have the requisite qualification at that time. The person, my lord, who was promoted by the private respondent, that school was provincialized in the year 1991. And she received a graduate scale of pay in 2004. Definitely, the private respondent is senior, and the promotion is required to be made on the basis of seniority. And she was promoted in that particular school, but she was transferred in that particular school, and headmaster was transferred to that school. That particular headmaster, he did not approach the High Court. He did not agree with the order of transfer. Now the question arises, my lord, whether the person who does not have the requisite qualification for appointment can, my lord, assail the order of promotion, my lord. And that is the point. I have already, lordship, submitted the judgment in that 2 points, my lord.
No, earlier you said that the district-wise seniority
Yes,
list
yes, prepared
and will be completed in
And
this
now,
month.
my lord,
Has it been completed?
my lord, has been completed, and the advertisement for the post of principal of higher secondary school has already been issued. And the post of headmaster of high school also, my lord, advertisement be issued, who will be the eligible teachers, will be considered. And the petitioner, meantime, she got the requisite qualification. Definitely, she can apply, she will also be considered. There is no question of that. And the person who was transferred, he has already retired from service. So the question of my lord, asking him to submit a representation in the docket does not arise at all. And the record does not reveal anything on that, my lord. On the basis of hearsay, on the basis of some statement of some other person before someone, those type of statements should not be made before this court, my lord.
Where are the advertisements?
My lord, advertisement for the post of headmaster, principal of the high secondary school, but his school is high school. High school has not yet been issued, my lord, but it will be issued shortly, my lord.
When are we issuing it?
My lord, definitely, if you lordship, I can, when it will be issued, my lord. And that instruction at this moment does not have. My lord.
Okay. For the higher secondary school,
It has already been issued, my lord, and that is also on the basis of district-wise seniority list. It will be considered.
where's the district-wise seniority list?
District-wise seniority lordship has not yet asked. We have not yet submitted, my lord. District-wise seniority, his name should be there, my lord. I can produce.
Your lordship, on the last occasion, your lordship want a specific answer, my lord. To that, they may say that it is not district-wide, school-wise seniority. This is the judgment they have cited. That lordship may say para 6 of the judgment.
Which judgment?
They produced 12636 of 2020. On record, my lord, that judgment lordship order may be seen, my lord.
2636.
Yes. Lordship say para 6, my lordship. Mr. So-and-so learned counsel for KAC further states that although the rules of 2018 had not been adopted by KAC as required under the provisions of 6th schedule to the Constitution of India, but at the same time, the spirit of Rule 14 of the Rules 2018 is being followed by the authorities. In following spirit of the Rule 14, it is contended that instead of a district-wise seniority list provided under the rules, the authorities in the Karbi Anglong follows the procedure of school-wise seniority list, in respect of which the promotion to the post of headmaster is made. So lordship asks, because he was of the same school, so what was the necessity to transfer him there, my lord? So that was the question, my lord. Now he is diverting, again going to the merit of the case, that the school was not provincialized. That is not the question posed by your lordship. So he must produce the record that what is the school of seniority, then the headmaster would have been promoted that time, my lord, and he would have continued till 2003 December. Then by the time I become eligible for the promotion, my lord, I become 10 years, I complete, my lord. Then why he has been transferred from one school to other school? This is impleading order is page 32 may be seen, my lord. In pursuance to letter number so-and-so dated so-and-so, issued by the Deputy Secretary Department of Personnel KSC DIFU, and in the interest of public service, Ms. Bobita Inti Katharpi, MA History B.Ed, Assistant Teacher, Graduate of Longleat High School, is hereby promoted to the post of next higher rank to the full-fledged headmaster, with transfer to act as headmaster of the KDIP High School in the scale pay of 2 rupees so-and-so, plus other allowances admissible under the rules from the date of joining Vice Jugeshwar Saike Headmaster KDIP High School transferred to Longleat High School. So this is the promotion. So that's what Lordship was asked. So he must produce the records to that effect, my lord.
This one question this court asked
My lord,
was when there was a full-fledged headmaster
My lord.
in the that what we call Kirtap High School or
Kildare High
whatever.
School, my lord.
What was the necessity to bring the respondent number 5 as the
To that
principal
particular
of that
school, my
particular
lord.
school?
My lord. The records, my lord, reveals.
Is it there in the
Yes,
records?
yes, my lord. Record is there.
Let us see what is there.
My lord.
There has to be some reason.
Yes, my lord.
In the meantime, Lordship may see that page 46, my the proposal of the inspector of school. Filed by them, my lord. Their affidavit.
This is not in public interest.
It reveals, my lord, my lord, regarding transfer like that way, my lord, transfer is like that way. But regarding promotion, my lord, on merit, the petitioner does not have. Yes, my lord.
Promotion
Yes, my lord. Yes, or lordship earlier only
is a
indicated
transfer,
on that.
transfer
Yes, my
order
lord. Yes, my lord. On the basis that.
in public interest.
My lord, on the basis of that, my lord, what the record reveals like that. And but Lord, as the petitioner at that time does not have the requisite qualification to hold the post of headmaster also as in charge, for holding the post of in charge also the person must have the requisite qualification. That is the law laid down by the Honorable Court also, and that is the law. As the petitioner.
No, that's fine. That's fine. That part. would
And
come
regarding
later.
that part, Lordship must appropriate. I have nothing.
No, the R5 has retired.
My lord.
You are still holding.
Earlier headmaster retired, my lord. And my lord, see, the petitioner is private respondent is working in that particular school now. as
Still now?
headmaster. Still. DPC minutes is there also, I thought. That's it.
Anything in the note sheet?
I have not checked the note sheet, but
Just check up.
but in the, I think there is nothing in the, like
There
this,
should be in the note sheet on the basis of this letter.
this one.
You do one thing, you go through the whole file properly, check up the note sheets. We'll take up on a other day, and then you can come prepared.
Then Lordship, I'll not be available from tomorrow, my lord.
Where are we going?
I'm going to my lord, Delhi, my lord. That is some case. Let it be after some time, my lord. My lord, today itself, my lordship. You can.
Okay, after some time.
After some time, my lord.
Then.
My please, Lordship. On last occasion, my lord, the matter was heard elaborately, my lord, at length. Now question arises, my lord, regarding the PhD. And so far, my lord,
1 minute.
advertisement is concerned, that is page 55.
This was heard earlier?
Well, Lordship has heard it, and there was one issue which Lordship wanted a clarification from our side. In the interview process, the purported, my lord, supervisor of the person who was appointed had also participated in the interview process and had given more marks than necessary is his allegation. Now, what I find is, my lord, that allegation has come up in the affidavit in reply. And the person concerned who is supposed to have given him more marks or had any bias or any, he is not a party before this honorable court as of now. I will not be able to answer as to what are the marks he had given or under what he had given marks, if any. So if that allegation of malice is to be proceeded with, my friend, my lord, has to implead him as a party so that his affidavit will be on record, because it's an interview process and it will go to his integrity part where we'll have our doubts. On the other part, my lord, whether a certain subject
Are you pressing that ground?
Lordship, that is, I have in reply narrated that supervisor
No,
also
that's
has
fine.
taken.
Are you pressing that ground?
Lordship.
You are pressing.
Yes, I am pressing, but my lord, so far that ground is concerned. Beside, my lord, the
Okay, that's okay.
judicial order dated 22/4/2024, Lordship, kindly have a look, my lord. That has not been complied. On what basis ineligible candidate have been 22/4/2024? This is judicial order, my lord, and has as yet not apprised. On what basis this ineligible candidate have been shortlisted? So far, this regulation notification 18 July 2018 is concerned, and the advertisement is based on this notification. But that has not been followed. So far, notification is concerned. I have, my lord, narrated in my reply.
That he's talking about.
In my reply, my lord, page 88, my lord. This is, my lord, prescribed table, my lord. Page 88, my lord. That has not been followed. She doesn't have PhD, and also at the time of application, no any paper publication was furnished. Whereas, so far my case is concerned, at the time of submission application, I have submitted all my paper publication, and thesis also submitted before the interview board. And on the basis of this thesis, also mark given. So it is admitted fact that I have a PhD, and this notification, my lord, says that it is a mandatory. So far,
Where's
this
that notification?
Lordship, this is notification, my lord. And advertisement, my lord, on the basis of this notification, my lord. Page, my lord, 55, kindly have a look for a moment, my lord. This is the advertisement. And advertisement still reflected that 18 July 2018, this for the maintenance of standard in higher education. And if the person have no PhD, so how it can be standard? How it can be maintained standard education, my lord? So, my lord, this notification, 18 July 2018, Lordship, section 3.10, my lord. I have given the flag mark, my lord, section 3.10. Here clearly mentioned that the PhD degree shall be a mandatory qualification for direct recruitment to the post of assistant professor in university with effect from 1/7/2021.
Yes.
An advertisement was published, my lord, on 1st of January 2022. So this notification is covered and also this 5/1/2022, page 55. And regarding the date of this notification,
What is the
also
prescribed qualification in this notification advertisement?
qualification, my lord, that is section 3.10. This is mandatory.
Under the advertisement,
Under the advertisement, my lord, here is just followed that so far this notification. I'm reading, my lord, the advertisement. Application along with 8 photocopies of the same in the prescribed form of the university are invited from the intending eligible candidate as per UGC regulations on minimum qualification for appointment of teachers and other academic staff in universities and college, and measure for the maintenance of standards in higher education 2018, dated 18 July 2028, that I have given lordship, for the following post so as to reach the undersigned on or before so and so. Now, my lord, so far applied geology, my lord, C, my lord.
You applied for assistant professor.
Assistant professor. And here, my lord, prescribed specialization, metamorphic petrology, geochronology, isotope geochemistry. And I have this specialization. So far, my PhD course is concerned. And prior to that, complete my PhD in the year 2015, I have completed the course, PhD course, my lord. Coursework, my lord. That is also necessary for Guwahati University. Prior to go submit thesis, that one person has to successfully completed PhD course that I have completed successfully PhD course. That is page 22.
And the response number 6?
No, nothing. Just he registered for PhD.
When did she complete?
She has not completed.
Not yet.
No. And so far, my lord, this reply, my lord, page lordship, page 88, my lord. Page 88. This is to be followed regarding shortlisting. And therefore, this one report pass order on 22/4/2024. On what basis this ineligible candidate, how can we shortlisted?
88 Annex X.
Yes, lordship. Table 3A. This is abstracted from this notification. Page 107 notification. And here, my lord, this is the prescribed qualification. MPhil, PhD mark also given 30. And I have, when I submitted the thesis, mark also given on the basis of the thesis. And that marks prescribed, that marks list has not been produced before this report. This is a concealment of the fact. And now that the university trying to establish that respondent number 6 is eligible candidate.
You have the reports.
My lord, I had called for the records, the scanned copy was sent. It was not very clear on that. So I have asked him to send me the entire the entire file I have asked for it. I should be able to get it maybe by the end of this week, my lord. Next week, if the matter is taken up, I'll have the records.
Next week is motion week only.
First week of January, then, my lord.
Oh,
I'll have the
first week
records.
of-
That is one part, my lord. And the second part is, he'll also make a statement whether at the time of submitting the
So,
application form,
Bhuyan,
Yes, I have additional file, additional evidence with this submission.
whether he had
no, that affidavit in reply where you have alleged against this particular person.
Lordship.
Now, if you are pressing that allegation,
I will make party.
you'll have to make a party. So you can think about that.
And also, my lord, I file additional affidavit regarding my today's submission, whether on the basis of my thesis mark given or not.
Whatever they heard, Mr. K. Bhuyan and counsel for the petitioner. Mr. R. Majumdar and the standing counsel declared university shall produce the records on the next date fix. Stop. The petitioner is also permitted to file a petition affidavit. Stop. When do you want?
Within week.
No, no.
He brings on record the allegations that he's trying to bring on. I'll have the affidavit sent. They'll give me the instructions, we can have the matter after that.
And lordship
A little week after he files the
for newly
affidavit.
impleaded party and
That is up to you.
Whenever he files.
We'll have it in the,
notification.
2 weeks after you file your affidavit.
That means January.
Whenever after he files the
After-
affidavit, to my
after
instruction.
2 weeks.
High level.
Now let's
9.
Notes also reveal
Previous is that,
that
let us.
on that list. One.
Where's that?
On that draft minutes is placed before the my lord CM my lord and he approved it.
Okay. Where was that other one that,
That my lord SCC marking is there, my lord. That quite in the note sheet, in the records, my lord. I think 131 serial. SCC marking.
page 131?
No, my lord, SCC marking is there. About and that is my lord SCC. My lord,
You have anything to say?
Nothing, my lord. That is only, but the transfer is totally illegal, man. Promotion, he may be promoted or she may be promoted. That is a different thing, but he cannot be transferred from one school and another school when they are himself admitted that is a seniority wise, school was seniority. And
That's
but-
fine. The only thing is that the incumbent was transferred.
yes,
He did not make a complaint.
that is a point.
no, that's a
That
different
is
thing,
the
my lord.
issue.
That is right.
But then my right can be violated, my lord. That lordship will see that, my lord.
She does not
He-
have the right.
My lord,
At that particular period, she does not have the right. Now she have the right.
Okay.
lordship will see that.
You do one thing. You do one thing. I don't know where I kept my notes. You make a short arguments, written arguments. You
Well-
submit it.
I'll submit.
Okay.
Tomorrow, my lord.
All can we- Huh?
Necessary.
all parties.
And I have already submitted my written argument. And the judgment also I have already referred.
You are respondent for?
I am respondent to my lord.
Respondent, my lord, 2, 3.
I am respondent number 4, my lord. I have submitted already.
Four.
This.
My lord.
Okay.
And the judgment also I have submitted, one Supreme Court judgment
That is the.
regarding the qualification, my lord.
Okay, heard by J. Royal and the senior counsel assisted by Mr. R. Hamarika, and the counsel for the petitioner, as well as Mr. J. Chutian and the standing counsel KSC, and Mr. B. Jagavati, and counsel for the respondent number 5. When can you submit your arguments?
Next week.
Chutian is not there. You are going out.
Let it be CV, my lord. I will submit on Monday, my lord.
No, he's not there. No, he's going out tomorrow.
3rd January, 2020.
Okay, list the matter on 3rd January. There will be some.
Seven.
We'll have it on 6th
6
for submission of written argument. On that day, you produce this
My
report.
lord.
Okay,
6 January.
11.
you give him the records.
May please, your lordship. Lordship, this case is related to a non-payment of a salary, my lord, for a retirement employee, my lord.
Kaushik,
My lord. Yeah, we have not received the instruction yet.
My lord,
Your lordship will kindly give us 2 weeks time. Let it be immediately after vacation.
I'll give a fixed date.
Fixed it.
my
What,
lord,
Mr.
K Das, your lord.
K. Das, London Council for the petition. On request made by B. Kaushik, London Standing Council, Elementary Education Department. When do you want?
After vacation, maybe. Can I be 8 minutes?
8.
Oblige.
Available in instructions.
12 order.
May please, your lordship. Your lordship may kindly peruse the last order, dated 22nd of November.
Yes.
My lord, my instruction is, my lord, that so far as 20 teachers in the elementary is concerned, my lord, their proposal is sent by the DEO to the directorate. That is my instruction, subject to what instruction my learned friend has. But so far as that 4 petitioners, who are, my lord, because of the amalgamation, they have gone under the secondary. Their proposal has been sent to the, my lord, by the headmaster to the IS, that is the D, who is also holding the post of DEO. That is my instruction.
That is almost the correct part. What I have to add to that is this. We receive a certain budget for the year. Now, what we have calculated is it is a sum of rupees around 13 crores. And we are placing a supplementary demand to the finance department for allotment of that money. It is only after the allotment of the money comes to us that we can next process the proposals or the payments. This will require some time because the SD proposal is not done only at the our level or
This contempt was filed in 2018. Why are you taking those steps now only?
a lot of water has flown after that, in the sense that we found, or the department had found many faults in the service career or the appointment of the petitioner, which was taken up to the level of this Honorable Supreme Court also, where it was dismissed on the ground of delay. And now that is why now with all avenues having been exhausted, we are trying to make the payment as it is made. And even as of today, what I'm told is one of the petitioners is still facing criminal trial because of impersonation or whatever fraud, other things related to this particular appointment process itself. So therefore, this matter from 18 to 22, 18 to 24 was a time period matter where we had filed reviews, we had filed appeals, we had even gone up to the Supreme Court. The Supreme Court matter did not interfere only on the ground of the delay that was ordered. So now we are processing it. It's not that we do not want to obey the orders of the court. The only thing is that the technical part, our recourse to avenue of law and now the technical part. What my letter, my lord, says is, at present, the Office of the Director of Elementary Education is not in a position to furnish the proposal to the
Give
government.
me your instructions.
Other paperwork have been done, but without the money coming to us from the finance man, it will be difficult.
আচ্ছা ওটা আসলে ইম্পোর্টেন্ট নাই রিপোর্ট হচ্ছে
সুপ্রিম কোর্ট অর্ডার করতে
My lord, may I add a little, my lord?
Yes, I mean, it took him more than 2 weeks to send the proposal. Correct. No,
That is what the records will reflect. That is because
no.
they are not only.
After this court passed this order on 22nd,
My lord.
again he wanted to delay it a little bit, and just when it is about to come up, that was yesterday, he sent it.
With all apologies, I would say, my lord, it is not an attempt to delay.
No, no.
Attempt to, my lord, lordship will
I'm
see the amount
on
involved,
the
my lord.
attitude of the DEO.
The
On 22nd, this court passed an order after reflecting all the communications made, said that personal appearance has to be called for. But then on the intervention of Chishti, this court gave him some time. Then immediately he could have sent up the proposal, but he waited till yesterday because the case is listed today.
My lord, on 9/12, there is a letter, and 7/12, then there
Here
is.
it says an error proposal along with relevant documents has been received by this directorate on 11/12/2024 by DO Morigaon letter under reference.
28/11, my lord, 28/11, he had written to the block elementary education officer. That is there, my lord. That would not be reflected in the director's notice. What he did at his level with his below officers here, 28/11, my lord, he had processed. That was perhaps not that. Also will find that is from the DEO to the BEO, my lord. And I required these things. The corrections required everything he had to calculate out, and he pointed out some.
Okay.
BO has not sent the, my lord, proposal of the 4 petitioners which are in the secondary, my lord. That has not been sent to my instruction. And so far as the
How
SL
about the 4 petitioners who are they'll come under the
secondary now
secondary
because of
education.
amalgamation.
Secondary education is not a party, my lord. I could not get it. I'll try to have that information.
IS is the DO, my lord.
Hmm.
The same
I should
person.
be the same. I do not
Same
know whether he has
person.
processed or not, because what these are instructions or documents which I've got from the.
No, my lord, if they go on the point that, my lord, the DO is not a party, then, my lord, let the, my lord, director and the secretary be personally present and explain. my lord.
That solves the problem, my lord. There is no difficulty. If the director or the secretary can come and give out 13
No,
crores. of
because, my
rupees here
lord,
on,
it is said that, my
to
lord, he is not a
fulfill
party.
the
He is not a
orders of
party.
this honorable government, there is no difficulty. Let them come, let them sell their houses and give the 13 crores. If that is how the court order is to be complied.
No, my lord, there are certain things which are not, my lord, correctly stated.
Persons who are not-
Firstly, my lord, the SLB was dismissed not on the ground of delay, it was dismissed on merit, my lord, firstly. Secondly, my lord, there are 28 petitioners. I am, my lord, now pressing for 24 because of the fact that there is one criminal case against one person, my learned friend has said. I am not pressing for that. Out of the other 3 persons, my lord, one has retired, and, my lord, 2 persons have joined some other job, and one has expired. Therefore, my lord, we are not pressing for that. But the SLB was dismissed on merit. And thereafter,
I may have been wrongly informed. I consider if there is an order.
my lord, your lordship will kindly see the SLB, my lord, order of the Honorable Supreme Court.
I was wrongly instructed. I called for NJ to name it. That is what was told to me.
This case
And no,
all
my lord,
all along handled by Mr. NJ Khatina. He has some difficulty, so he has requested. So that information may not come correctly. Then we are considering.
Those are.
and my lord, earlier the DU was given the personal appearance. Only 1 page order, my lord. The same order, personal, I'm sorry.
Okay, how about the other 4 petitioners?
Matter that secondary division partner will give me some time. I'll try to find out. I'll give him a call and I'll find out.
Okay. So presently there are 28 petitioners.
28 petitioners. I am not pressing for the other four, my lord. One is that there is a criminal case, one person has died, one person is, my lord, retired.
Okay, I'm not mentioning
That, my lord, your lordship need not mention.
but Mr. M.K. Chowdhury, Learned Senior Counsel, assisted by Mr. M. Datta, Learned Counsel for the petitioner. Stop. Mr. R. Majumdar, you are appearing as a counsel,
As a council.
As a council.
Learned Counsel, appearing for the respond number 4, Public Director of Elementary Education, Assam. On instructions, submits that the error salary proposal, along with relevant documents, has been received by the respondent number 4 on 11/12/2024 from the DEO Morigan for an amount of rupees 13,12,96,416 only, and the same has been sent for verification in the directorate for onward submission to the government for according sanction. Stop. He also submits that the Office of the Director of Elementary Education, Assam, is not in a position to furnish the said proposal to the government because of insufficient funds, insufficient budget provision for the financial year 2024-2025 under the respective head of the office for payment of error salaries to the teaching and non-teaching employees of UP schools working under the DEE Assam during 2024-25. Stop. He submits that the respondent number 4 will be taking initiatives for additional budget provision by way of submission of supplementary demand to the government for the financial year 2024-2025. Stop. Para. As regards the other 4 writ petitioners who are presently under the Secondary Education Department, he prays for a short time to enable him to receive instructions. Stop. Para. When do you want it?
Supplementary demand, once you place it, will take some time.
No, at least show us something that you are doing something.
Yes, that it has been forwarded.
The
First week of
something.
January,
Okay.
first week of January, lordship places it.
Okay. Accordingly, list is matter on. Give a date convenient to both of you. Except Friday.
9th January,
Nine or no, do that house very, very.
7
Seven, no, that's 7.
আজি কিমান তাৰিখ প্ৰটেজৰটো পঠিয়াটো দেখুৱালে হ'ল ন সেইখিনি পোৱা যাব কেতিয়ালে January. Any dates first week of January. I have
List on
7th?
8th.
8th.
January.
Yes. 8th. I'm obliged, madam.
Well, I'll take the copy of the swimming course order
Yes.
because I don't have any other copy. Let it be there, my lord. I think there are 2 copies.
You can keep it. It's okay.
Obliged.
Highly obliged.
Hello, the order of 2018 to pay the area of the base salary within 3 months and to give the basic scale of pay. Now we are in 24, my lord, 6, 7 adjournments have been taken. So personally, I requested the petitioner to go to the department and check where the file is lying. I think, my lord, your lordship has to order the respondent number 2, the Commissioner and Secretary of Finance, who is holding the file, my lord.
It is in the, under
Yes.
consideration
So
of
I think, my lord,
department.
Jayanta Narlika, Commissioner and Secretary to the Government of Assam Finance Department, this pool has to be asked to be present in person, my lord. That is the only way, your lordship.
Yeah, who appears for R6?
I already have.
Fine.
He is holding the file, my lord, not passing anything. No subordinates goes to his office room.
Notice has gone to him?
Yes, my lord. The appearance, they have, no, none of the respondent has filed a affidavit, but he has, he was impleaded on 25/20/22. And your lordship will see, on 17/7/2024 order also.
Twenty?
Your lordship will see the 7/8/2024 order first. The respondent number 1, 2, and 3 submits that a proposal has been sent to the Finance Department on 6/8/2024. He is respondent number 2. Prior to that order also, your lordship will find 17/7/2024. The respondent submits that the case of the petitioner is under consideration in the Finance PRU Department, my lord.
Yes.
I can have the instruction otherwise. Thought that I can have, because if the proposal had been submitted.
No, see, if you read from the month of July, 17/7/2024, the file is lying on your table.
No, that's why I can have the instruction melody. Sorry, that is given to me. Because my lord,
Okay.
nobody is representing, I can have the.
I can give you a time because, but you should keep in mind that the file has been on your table from
That
the month,
instruction I will have,
from the month of July 2024.
Document reflected in the order, I will have the instruction.
Even on the last date on 22/11/2024, also your lordship will see the order, my lord. Mr. Gogoi appeared for the respondent number 1, 2, and 3. Kego.
Okay, heard Mr. B.D. Conway, Leonard Senior Counsel, assisted by M.S. Zomanpui, huh? You know, ZOMUANPUII. Okay. For the petitions, stop. A perusal of the orders passed by this court would indicate that the consent file in respect of the petitioners has been under consideration in the finance written packet PRU department since 17/7/2024, as since the month of July 2024. Stop. The learned standing council, the learned council for the respondents 1, 2, and 3 thereafter had made the same submission on 7/8/2024 that the proposal has been sent to the finance department. Stop. No, don't say. The perusal of the request indicate that the file in respect of the petitioners has been lying, it has been under the consideration of the finance PRU department since July 2024. Till date, comma, it appears that the finance department is yet to take a decision in the matter. Stop. Para. Is yet to give a decision and give concurrence to the proposal made by the respondents 1, 2, and 3. Stop. Para Mr. B. Gogoi, learned counsel appearing for the respondent number 6.
Yes, madam. Jayan Narlika.
Respondent number 6.
Jayanta Narlika.
Pressed for a short time to enable him to receive instructions with regard to the outcome of the case of the petitioners. When?
Anytime, my lord, convenient, my lord. If on the reopening, my lord, or next week on Friday, I can have that.
Friday will be difficult.
Yes, that's why on my lord, immediately on reopening.
They should
On-
pay. I have also given them a idea that you at least first pay these 23 petitioners who are before your lordship instead of looking for the entire Assam. Then you can close this petition, contempt petition, at least 24. Because others are sleeping over their rights, let them sleep. At least consider the case of this first 24 petition. So yeah, we can have it after vacation. my lord.
On 6th.
Okay.
Six.
This is the matter on. Can you have it by 6?
Yes, yes.
Yes, yes.
No, my lord, 7.
7.
7.
7.
Well, I cannot see. Marega kya? We are blessed.
14, 15 and 16.
Maybe reflected.
Registry is also directed to reflect the name of Mr. B. Gogoi as the learned counsel appearing for the respond number 6 in the cost list.
My lord, I have filed an IA, my lord.
What is this?
My lord, it arises out of the an order passed by this honorable court regarding granting time scale of pay with effect from 2011 under section 44 of the Guwahati University Act. My lord, I take your lordship straight to page 28. The order, this honorable court's order in review petition, page 28
Of the IA?
of the IA. First the facts, my lord, then the other aspects, my lord. The first order was of 2019, my lord. And in that order, without considering section 44 of the Guwahati University Act, my lord, which contains the approval part of the state government. My lord, without considering that section, my lord, that order was passed. And thereafter, we have moved a review petition, my lord. And page 29, my lord, the order in the review petition, page 29. May I read, my lord? Very short order, my lord.
Okay.
Page 29. The review petition has been moved by Guwahati University Authority.
Oh.
1/8/2022, page 29. Heard so and so, learned counsel also heard so and so. 2. The present review petition has been filed seeking certain clarification as regards the direction issued by this court in WPC number so and so on 8/11/2019 as follows. 7. Under quotation. Considering the submissions of the learned counsel for the parties and on perusal of the materials on record, the writ petition is disposed of by directing the respondent authorities, more particularly respondent number 2, namely Registrar of Guwahati University, to do the needful for granting time scale to the petitioner against a permanent vacancy in terms of the rule referred to above, which is framed by the university authorities themselves. The petitioner will also be entitled to get regular pay scale with effect from 11/1/2011, that is the date of her initial appointment as assistant teacher, as had been given to others. That was the order, my lord, 2019, but without considering section 44. Now the next parameter. Our stand, Guwahati University stand in that order, my lord. It has been submitted by so and so, learned counsel for the university. Next page, my lord. That it is important, my lord. Though the university authorities have taken all the necessary steps as contemplated under paragraph 7 of the aforesaid direction, yet the same could not be implemented because of lack of prior approval of the state authorities under section 44 of the Guwahati University Amendment Act 2013. This court would clarify that the university will accordingly seek the approval of the state government so that the direction as mentioned in paragraph 7 referred to above can be given effect to by giving necessary approval to the same. So, my lord, in this review petition, order has been, my lord, issued, passed by this honorable court, that approval should be given by the state government, and that was not in the earlier order. Next page, next parameter. It may be noted that when the said order of direction was issued, it was in presence of the respective council for the higher education as well as finance department of the state, and as such, This court is of the view that there should not be any difficulty on the part of the state government to give the necessary approval for appointment of the petitioner, which has been sought by the Guwahati University authorities via their letter dated so and so. So, my lord, higher education as well as finance department, my lord, both were parties in the earlier petition and that review petition also. And my lord, there would not be any difficulty to implement the order. My lord. Now, next, para 5. Mr. So-and-so London Standing Council for the Higher Education submits that because of change in the allocation of business, the matter relating to appointment of the petitioner will come under the purview of the secondary education. This code would also clarify that when this order was issued on 8/11/2019, it was within the purview of the secondary education department, and as such, if there is a change in the allocation of business subsequently, the secondary education department will be the responsible department, and it will be incumbent upon the said secondary education department to do the needful. Accordingly, the direction was issued, my lord. Accordingly, the secondary education department as well as the higher education department will coordinate with each other for approval and appointment of the petitioner as proposed by the Guwahati University. The aforesaid exercise shall be expected to be completed, preferably within a period of 2 months from the date of receipt of certified copy of the order. With the above clarification and observation, present review petition stands disposed of. So thereafter, my lord, we can skip the other, my lord, enclosures, annexers, my lord. We take your lordship straight to page 39. The response of communication, my lord, dated 9 July 2024, page 39. Mary,
Yes.
page 39. This is very crucial, my lord, since, my lord, court has directed to grant approval with effect from 2011. This is the response communication from the Higher Education Department, issued by the Secretary to the Government of Assam Higher Education Department to the Register Guwahati University. Subject special approval for granting time scale to so-and-so, appointed on compassionate ground from date of joining, and reference Honorable Guwahati High Court order. Sir, with reference to your letter of ID number so-and-so, it may be mentioned that the proposal was examined and it is found that the petitioner, that is Srimati Mridula Sharma, was appointed as an assistant teacher in Guwahati University Model AC School on compassionate ground on 11/1/2011, and she joined on 12/1/2011. The Guwahati University Act 2013 came into force from dated 30/5/2013. As the petitioner was appointed before the commencement of Guwahati University Amendment Act 2013, therefore, the university may consider the compliance of Honorable Guwahati High Court's order as per the existing act during the time of appointment of the petitioner. However, any appointment after the commencement of Guwahati University Amendment Act 2013 shall be strictly considered as per section 44 of the said act. The Guwahati University is requested not to refer any appointment proposal to the government which violates the section 44 of Guwahati University Act 2013. So, my lord, the sum and substance of this crucial communication from the government to the Guwahati University authority is that no approval is required, and since the appointment is prior to 2013 amendment, so, my lord, the Guwahati University may accordingly, my lord, grant the time scale. But this is not in tune with the order passed by this honorable court. This honorable court passed order that approval should be given by the state government with retrospective effect. Finance department is also, my lord, involved. Higher education, secondary education, all the departments are involved. But as per this letter, no approval is required. It is little bit like revisiting the earlier order. 2 contempt petitions are pending. So the matter, my lord, needs special, my lord, consideration by the Guwahati University Authority. So, my lord, the next page, Annexer 10, page 40. A detailed representation has been submitted to the Secretary to the Government of Assam Education Department
narrating entire facts. My lord, I will refer only the page 40 as well as page 45 onwards. Page 40, my lord, annexure 10. First few lines, my lord. It is addressed to the Secretary to the Governor of Assam, School Higher Education Department, and subject is approval for granting time scale to Srimati Mridula Sharma. Sir, with due reference to the above, page 40, my lord. Page 40, dated 19 September 2024. Srimati Mridula Sharma's father, Mohendra Mohan Sharma, who was a teacher at Guwahati University Model AC School, died in harness on 3/5/1999 when Srimati Sharma was in employable age of 18 years, her date of birth being 16/4/1981. 2. That Srimati Sharma applied for employment on compassionate ground on 2/6/2009 after more than 10 years since the demise of her father. So, Mridula Sharma applied after more than 10 years, which is against the laws of the land, including that Achyut Ranjan Das and other apex court judgments. Mridula Sharma approached after 10 years since the demise of her father. 3. That during the relevant period at the time of application, Srimati Sharma's mother, Parul Devi, was an employed person drawing rupees 11,246 per month. It is also against the apex court judgment and Achyut Ranjan Das. Lord, her mother was an employed person during the relevant period.
Under your university?
Milord.
Oh.
Now, we can skip other paragraphs, Milord. Page 44. Since some in-depth analysis of the entire matter is required, Milord, so this detailed representation, Milord. Page 44. Last 3 lines, Milord, paragraph, internal paragraph 16, page 44. That very representation. That in this scenario, the Guwahati University immediately after aforesaid meeting held on so-and-so, by its communication number so-and-so dated 6/7/2024, has urged to arrange for, next page, Milord, has urged to arrange for special approval to grant time scale to Ms. Mridula Sharma, appointed on compassionate ground from date of joining. In response to the said communication of the university dated so-and-so, the crucial communication under memo number so-and-so dated 9/7/2024, I have just read, Milord, from the Government of Assam in Higher Education Department has been sent to the university, contents of which government communication could not be considered as an approval in true intent and purport of the aforesaid section 44 of the Guwahati University Amendment Act 2013. Rather, it is not an approval at all, which does not make any whisper or inkling about the vital financial aspect entwined and interwoven therewith all along. To make the matter worse, the State Finance Department's required approval has also been not taken prior to issuance of the instant purported approval communication. Paragraph number 3 and 4 of the Honorable Court's order dated 1/8/2022 in the review petition number so-and-so may be referred to. And the approval without the financial component therein in the present context is just an empty formality and not a legally accepted approval for all practical purposes, which can be acted upon by the university authorities at all to comply with the Honorable Court's aforesaid direction in this regard. 2 contempt petitions are still pending. Next para. It is pertinent to state here that the contents of the Honorable High Court's aforesaid order dated 1/8/2022 in review petition number so-and-so clearly emphasize that there should not be any difficulty on the part of the state government to give the necessary approval for appointment of the petitioner, which has been sought by the Guwahati University authorities by their letter dated 31/1/2020. Emphasize added, wherein the secondary and higher education department of the state will coordinate with each other within a stipulated period. For ready reference, The relevant contents of the said government communication dated 9/7/24 have been quoted below. The Guwahati University Act so and so.
That we have gone
Milord,
through.
I have already read, Milord. Next page. Please, 46. Please refer to the approval aspect clearly pointed out on behalf of the university in paragraph number 3, 4 of the above referred order of the Honorable High Court dated 1/8/2022 in review petition number so and so, focusing upon the university's earlier communication dated 31/1/2020 in the context of Srimati Sharma's entitlement to regular pay scale with effect from 11/1/2011, that is the date of her initial appointment as assistant teacher, as had been given to others, emphasis added, which was the direction of the Honorable High Court in its earlier order dated 8/11/2019, as passed in Srimati Sharma's above mentioned writ petition bearing so and so. It is stated that the scope of aforesaid section 44 of the Guwahati University Amendment Act 2013 has been taken into the zone of consideration only in the later order dated 1/8/2022 and not in the earlier order dated 8/11/2019 of the Honorable High Court, and consequently, the later order would prevail so far as to the respondents concerned. So that approval aspect of the state government. Paragraph 17. That the instant matter with its mind-boggling cascading effect, particularly concerning altogether 128 number of present employees, as indicated herein above, having huge financial impact in the days to come, has recently been decided to be placed as a priority item in the immediate next Executive Council meeting. So, my lord, it will open a floodgate, my lord. There are altogether 128 employees, and it will be a staggering amount of 70 crores that will be funded by the state government. Paragraph 18. That it may be pointed out in the instant peculiar context that there is a general principle which has been enunciated by the Honorable Supreme Court of India in Huda and another versus so and so, as reported in 2005 1 SCC 191, that the principles underlying are lex non cosit ad impossibilia. The law does not compel a man to do the impossible, and actus curiam renime gravivit, the act of court shall prejudice no man. Next page, Milord. In view of the aforesaid factual as well as legal metrics, it is requested again with an urgent note to accord necessary approval to grant time scale to Srimati Mridula Sharma appointed on compassionate ground, clearly indicating the appertaining financial aspect entwined therewith for the purpose of immediate compliance of the orders as passed by the Honorable Guwahati High Court in the instant matter. So, the representation's prayer is approval is to be granted in tune with the order passed by this Honorable Court, and there should be that financial component. Without financial component, that approval would be a meaningless, empty formality. There are so many cases, my lord. I'll refer to them a little bit later. Now, to this IA, the private respondent, Mridula Sharma, filed an objection on affidavit. My lord.
After 5-10 minutes.
Prior to that, my lord, 2-3 pages before that, my lord. The notification, my lord, dated 30th May 2013. The following act of Assam so and so, published for general information, and the effective date is 30 May 2013, my lord. The date is important. And now the section 44, my lord, the last page. May I read, my lord? 44, 1 and 2. The university shall establish and maintain the teaching and non-teaching staff ratio at 1:1.5 progressively. In order to establish this teaching and non-teaching staff ratio, the university shall not appoint any non-teaching employee afresh against sanctioned vacant post, and also shall not initiate for re-employment of any retired person upon their retirement without taking prior approval of the state government. So that prior approval would be required for appointing non-teaching employee, which is the case with the Srimati Mridula Sharma, the private respondent. Now, number 2, that is regarding financial aspect. The university shall not take any decision or adopt any new rule or scheme which may involve further outflow of funds from the state exchequer. So 44 and 1 and 2, both are entwined regarding that financial aspect. 1, approval, and then this financial component. Now, CPC, my lord. Order 47, Rule 9.
What purpose?
My lord, regarding, my lord, that affidavit in opposition, my lord, I'll, my lord, go into that contents of the affidavit in opposition a little later, my lord. My lord, on the basis of Order 47, Rule 9, my lord, my learned friends' contention in the affidavit in opposition, the basic contention, this interlocutory application is not maintainable. So, order, if we go to the contents of Order 47, Rule 9, it is regarding review provision, my lord. The last 2-3 lines, my lord. Bar of certain applications. No application to review an order made on an application for a review. Rule 9, Order 47. Bar of certain application. We can skip other provisions. Bar of certain applications. No application to review an order made on an application for a review or a decree or order passed or made on a review shall be entertained. So, no application for reviewing the earlier order, that reviewed order passed in 2022, 2 years back, could be preferred as per this provision. Explaining that provision, my lord, this honorable court, honorable Supreme Court, my lord, has recently passed an order in Supertech Limited.
No, Isha, what do you want in your IA?
My lord, that crucial communication of the secretary to the Governor of Assam in Education Department, that no approval is required since it's a 2011 employment. And since no approval is required, so university can go ahead. But as per the earlier order of this review order of this honorable court, that approval should be granted by the Governor of Assam, and finance department is also involved. So clarification is required whether that approval would be a empty formality or not. And as per the affidavit in contention of the affidavit in opposition, without going into the merits of the other, my lord, aspects, the maintainability aspect, whether the Guwahati University could prefer an application for reviewing the earlier review order, but it's not a reviewing application. So CPC Order 47, Rule 9.
No, why do you want to have a review of the earlier review?
No, no, we don't want to review the earlier review,
That's right.
my lord. Only that approval part, my lord.
So your grievance
My lord.
is that after you send the request for approval,
My lord.
they have put back saying that since the petition was appointed prior to the coming into force of the Guwahati University Amendment Act 2013,
My lord.
prior to that, so that the authorities in the Secretary of Higher Education, I don't know,
My lord.
they said that you can proceed,
My lord.
isn't that?
My lord. But the earlier order means, my lord, that review order of 2022 passed by this honorable court. considering all the aspects, whether that 2011 appointment order would be applicable to the 2013 Amendment Act and such other things, my lord. And considering the entire gamut of the
review order.
my lord. Page 28. Page 28 to 31.
We did.
Page 28 to 31. I again read page para 2, my lord. A short pyramid. Page 29. The present review petition has been filed seeking certain clarification as regards the direction issued so and so in 2000 on 8/11/2019. Considering the submissions of the learned counsel for the parties and on perusal of the materials on record, the writ petition is disposed of by directing the respondent authorities, more particularly respondent number 2, namely Register Guwahati University, to do the needful for granting time scale to the petitioner against a permanent vacancy in terms of the rule referred to above, which is framed by the university authorities themselves. The petitioner will also be entitled to get regular pay scale with effect from 11/1/2011, that is the date of her initial appointment as assistant teacher as had been given to others. Miller, thereafter, Miller, this paragraph 3, Miller, it has been submitted by so-and-so learned counsel for Guwahati University that though the university authorities have taken all the necessary steps as contemplated under paragraph 7 of the aforesaid direction, yet the same could not be implemented because of lack of prior approval by the state authorities under section 44 of the Guwahati University Amendment Act 2013. This code would clarify that the university will accordingly seek the approval of the state government so that the direction as mentioned in paragraph 7 referred to above can be given effect to by giving necessary approval to the same. So this was the submission of the Guwahati University in the review petition, Miller, and then the order passed in paragraph 4 and 5. Paragraph 4. Miller. So, Miller, the direction of the review passed by this honorable court in review petition is that approval is to be given by the state government, and that order has not been modified as yet. So, without Miller giving that approval, that since the appointment is of 2011, there is another aspect, Miller. Miller, for that, Miller, we will have to go back to that 2019 order. If I may be permitted, Miller, that 2019 order is also there, Miller. Page 22 to 25. Why this 2013 Amendment Act would come into effect? Though appointed in 2011, page 22 onwards, Miller. Page 23. Now, Miller, we can skip para 1, 2, 3. Now 4, Miller. Para 4, page 24. The earlier order in the writ petition. By drawing attention to Annexure 6 to the writ petition, which is report of the committee regarding compassionate appointment under the Guwahati University, learned counsel for the petitioner submits that as per para 3 of the rules framed by the Guwahati University for appointment on compassionate ground, a person appointed to category C and D on compassionate ground is entitled to be placed in the time scale against permanent vacancy on completion of unblemished service of 3 years. 3 years, Miller. It is submitted that since the petitioner was appointed on compassionate ground on fixed pay in the year 2011, and as she has already completed uninterrupted and unblemished service period of 3 years, she is entitled to be appointed against permanent vacancy, and by not doing so, the respondent authorities have caused great prejudice to her. It is also contended that there are vacancies available in various grades C and D posts. 5. The relevant portion of para 3 of the rules framed by the Guwahati University reads as follows. It is important, Miller. Persons engaged on compassionate ground to category C and D, as the case may be given fixed pay with effect from the date of his/her employment. It is from 2011, Miller, in the instant matter. On completion of unblemished service of 3 years, that is in 2014, Miller, after the amendment. he or she be placed in the time scale against permanent vacancy. Learned counsel for the respondent submit that the case of the petitioner can be examined by the authorities, and if it is found that the petitioner is entitled to be placed in time scale against permanent vacancy as claimed by her, there would not be any difficulty in appointing her against a permanent post as per her eligibility. So, my lord, appointed in 2011, but in my lord fixed pay, and time scale would be granted from 2014 after completion of 3 years as per rules framed by the Guwahati University authorities. In view of this rule, my lord, that Amendment Act of 2013, which is in force from 30 May 2013, my lord, would come into effect, my lord, would come into play. So that is why this honorable court in review petition has directed that approval must be given by the government. And government means, my lord, state government, that education department as well as finance department. And which education, my lord, department would, my lord, do the, my lord, approval, my lord, grant the approval, the secondary and higher both coordinate with each other. So, my lord, this is the backdrop, my lord. And that crucial communication of the state government is that no approval is required. And another crucial aspect, my lord, the financial grant is from the state government. Entire financial aspects of the university, my lord, is my lord, managed, my lord, granted by the state government. So that financial aspect, my lord, if we appoint some, my lord, person, my lord, Mridula Sharma or my lord, that 128 employees, my lord, then that financial, that budget allocation, everything rests upon the state government. So that is another aspect, my lord. But it is loud and clear, my lord, this honorable court, my lord, passed that order that approval is to be granted by the state government. And that cannot be revisited without reviewing that order. That order still stands. Very simple, my lord, approval is to be given by the state government, then Guwahati University will give time scale. So, my lord, but that crucial communication of the state government dated 9/7/2024, Annexure 9, page 39. It is clear, my lord. It is akin to the revisiting of the review order that no approval is required. There is no discussion about that financial aspect. And 2 contempt petitions are pending, my lord. So for that clarification, not for modification as per order 47 rule 9, as clarified by the Supreme Court in Supertech Limited, as pointed out by my learned friend, it is not an application for modification of that review order. It is for that interpretation of that approval aspect, my lord, whether it should be an empty formality, my lord. This honorable court and also honorable Supreme Court time and again, my lord, clarified that it should not be an
What was the existing rule when the petitioner was appointed?
Existing rule that, my lord, without amendment of, without insertion of
Prior
that
to
section,
the amendment,
without insertion of that section 44, no approval is required at that time.
and how about the monetary?
My lord, that budget, my lord, allocation, my lord, that is approved by the state government, my lord, to the university authorities, my lord. My lord, that system, my lord, prevails at the relevant period. But after that, my lord, that 2013 amendment, my lord, we cannot, my lord, appoint anyone, my lord, without approval of that.
According to them, is that since she was appointed prior to 2013,
My lord,
before the existence of that 44,
my lord.
then you proceed on your own. That's what we have saying.
But as per our rules, my lord, framed for compassionate appointment, first 3 years fixed pay, then unblemished service and other things, my lord. Then in 2014, my lord, after 3 years, my lord, she will be granted regular scale. So, my lord, that 2013 amendment would come into play, and that is why, my lord, considering the entire gamut of all these things, my lord, earlier there are several orders regarding interpretation of this section 44. So that is why, my lord, this honorable court in review petition, my lord, directed that approval should be granted by the state government. Without revisiting, without reviewing that review order, my lord. If
Yes.
so, my lord, approval, then another aspect, my lord, approval cannot be a, my lord, empty formality, my lord. That financial component must be there. And there another thing, my lord, the respondent Mridula Sharma, she was appointed while her mother was serving, my lord. That cannot be.
That can't, you can't raise that.
You cannot.
My lord, since my lord, Supreme
And
Court
it
is
should have been raised in the, when
Supreme-
the petition was
my lord, Supreme Court is clear, my lord. If there is an illegality,
going to that now. This is a contempt proceeding, isn't it?
my lord, not contempt, my lord. It is an interlocutor.
IA.
IA for, my lord,
IA in the
clarification,
contempt, isn't it?
contempt
Review, my lord.
in review petition, my lord. IA not for in contempt petition. Contempt petitions are pending. These are tagged together, my lord.
Who's the review?
Review, my lord.
35.
Yes, my lord. That was disposed
No,
of.
what reason, this review is part 35? 35 is disposed of.
Disposed of in
Disposed of.
my
Final
lord.
order.
My lord.
Then
In that final order, my lord, that communication has, my lord, been issued by the state government in,
practically what I'm trying to say
my
is,
lord,
now you find this IA in the review.
review.
Review is disposed
Yes, my lord.
in view of that non compliant.
My lord.
They filed a contempt,
Contempt, my lord.
isn't it?
That first order, one contempt, then second is
Whether
review.
this IA is also maintainable or not.
That is why, my lord, that maintainability aspect, my lord, I will refer to that Supreme Court's order as well as that CPC, my lord, Order 47, Rule 9. It is not for any modification of that review order. Modification and clarification to different aspects, my lord.
Can you file an IA and dispose?
Can.
Yes, my lord. We can, my lord.
Cannot.
My lord, since, my lord, that Supreme Court's order, my lord, I'll first go to that Supreme Court's, my lord, judgment, my lord. Whether it is maintainable or not. It has been referred by my learned friend, my lord. Anyway, my lord, that Supertech,
That point is clear, my lord. They can. Arapta charge, they do.
that Supertech Limited case, my lord. Recent case 2023, 10 SEC 817. That has been heavily relied by my learned friend in affidavit in opposition, my lord. So, my lord, first, my lord, paragraph 1 and 2, my lord. That Supertech Limited case, my lord. What is the actual purport of the meaning and purport of that Order 47, Rule 9? Whether one can, my lord, come forward with an interlocutory application, my lord. Para 1, my lord. A miscellaneous application has been filed, like the instant matter, my lord, but the contexts are different. By Supertech Limited seeking modification of the judgment. I'm not for modification, I'm for clarification. Little bit clarification, my lord, that approval aspect. Judgment and order of this court dated so and so. The reliefs, it has already been disposed of, on 31 August 2021. And this judgment has been rendered in 2023, after 2 years. The reliefs which are sought, it is important, my lord. The reliefs which are sought in the miscellaneous application read thus: modify the judgment dated so and so to the extent that applicant may demolish a part of tower T17 as stipulated in paragraph 6 herein above, and 2B, pass an order of status quo in respect of tower 16 and 17 in MRL court, plot number so and so, till final orders are passed in the present application. Now, paragraph 2. It is regarding the tower 16 and 17. Apex court held that 16 and 17 should be demolished. But by this miscellaneous application, they sought to modify that tower 16-17 demolition process. Para 2. A division bench of the High Court of Judicature at Allahabad directed the demolition of towers 16 and 17. It is important, my lord. Directed the demolition of towers 16 and 17 by the third respondent, New Okhla Industrial Development Authority, in MRL court constructed by the applicant and situated on plot number so and so, Noida. while affirming the judgment of the division bench, this court, this Honorable Supreme Court, has recorded the following conclusion in its judgment, which is reported as Supertech Limited versus so-and-so, online so-and-so. Now we can skip, Milord, internal para 186, next page, Milord, page 3. Last, Milord, 7, 8 lines, Milord, para 186, Milord. For the reasons which we have indicated above, we have come to the conclusion. It was the conclusion, Milord. The order passed by the High Court for the demolition of Apex and CN T16 and T17 does not warrant interference, and direction for demolition issued by the High Court is affirmed. So demolition process is, Milord, to be continued. No interference regarding tower 16 and 17. And next page and next para, Milord. The work of demolition shall be carried out within a period of 3 months from the date of this judgment. This is the context, Milord. And then, Milord, paragraph 11 and 12. Without the factual backdrop, Milord, one cannot go to the order 47 rule 9. Paragraph 11, Milord. The paragraph 11, last page, Milord, 8. The attempt in the present miscellaneous application, that attempt, Milord, is clearly to seek a substantive modification of the judgment of this court. It is not in the instant matter, Milord. It is regarding that demolition process should be stopped regarding tower 16 and 17. Such an attempt is not permissible in a miscellaneous application. It is true, Milord. While so-and-so learned senior counsel has relied upon provision of order so-and-so of Supreme Court so-and-so, what is contemplated therein is a saving of the inherent powers of the court to make such orders as may be necessary for the ends of justice or to prevent an abuse of the process of the order court. Order so-and-so cannot be inverted to bypass the provisions for review in order in the Supreme Court rule so-and-so. The miscellaneous application is an abuse of the process. Next parameter. Milord, my learned friend is, Milord, relying on this parameter. The hallmark of a judicial pronouncement is its stability and finality. Judicial verdicts are not like sand dunes, which are subject to the vagaries of wind and weather. See so-and-so. A disturbing trend has emerged in this court of repeated applications, styled as miscellaneous applications, being filed after a final judgment has been pronounced. Such a practice has no legal foundation and must be firmly discouraged. It reduces litigation to a gambit. Miscellaneous applications are becoming a preferred course to those with resources to pursue strategies to avoid compliance with judicial decisions. A judicial pronouncement cannot be subject to modification once the judgment has been pronounced by filing a miscellaneous application. Filing of a miscellaneous application seeking modification, clarification of a judgment is not envisaged in law. Further, it is a settled legal principle that one cannot do indirectly what one cannot do directly. So, Milord, the Supreme Court is clear. By filing an interlocutory or miscellaneous application, you cannot modify the order. You cannot review the order. But here, it is not for any modification, Milord. It is only regarding that approval part, Milord. Milord, whether that approval could be, process could be revisited. And whether that approval should be empty formality, Milord, without that financial component. I'm not against that approval part. I'm not against any modification of that order. But that order was very simple, Milord. That approval is to be granted by the state government. Then Guwahati University Authority will grant time scale to Mridula Sharma. But that approval, first, that crucial communication, no approval is required. And if approval is granted, then without consulting the finance department and without going through the other credentials of the Milord, Ms. Mridula Devi, Milord.
Who are parties in the contract?
Milord.
who are the parties in the contempt?
my lord, the Guwahati University Authority as well the Director of Higher Education and
Finance.
Finance,
So
my
some
lord.
parties?
Director of Higher Education and Director of Secondary Education and a registered Guwahati University. Finance department is not a part. By name, my lord. No, it's my lord. Their domain, my lord. Their my lord. Petition, my lord. Contempt case. So, my lord, my submission is very simple, my lord. Approval is to be granted by state government. Then the Guwahati University could embark upon the process of granting time scale to Mridula Devi. It is not about 2011 or 2013 Amendment Act or not. Whether 2013 Amendment Act would come into play, it has already been settled in the review petition, in that review order. So whether it is effective from 30th May 2013, whether Mridula Devi has been engaged in 2011, whether after 3 years she will get regular pay since 2014 as per rules framed by the university authorities as regards compassionate appointment. These entire gamuts of my lord, the aspects, my lord, have been dealt with by the this honorable court in review order. So ultimate outcome is approval is to be granted. But my my lord, contention is that whether that approval should be an empty formality, no financial component. But as per section 44(1) and 2, that is financial aspects are there, my lord, and twin there which. And since my lord, contempt petitions are pending, my lord, we will have to comply with it. And there is another, my lord, dangerous, my lord, thing, my lord. 128 employees, mind-boggling amount, my lord, 70, near about 70 crores. If it is, my lord, if it goes like this, my lord, no approval, no financial component, then Guwahati University will have to bear around 70 crores.
So that's what you're trying to say.
That approval is to
That-
be entwined with financial
The
component.
timescale to the petitioner, you have no problem. In view of that letter.
Miller.
But the financial consequence,
Miller.
you are not able to bear it. That's what you're trying to
Miller,
say.
Miller. And that those aspects, my lord, regarding, my lord, her credential, my lord, though in a later stage, my lord, that now has come into.
You cannot, that door was open when the writ petition was pending. Now it's closed.
But the Supreme Court is also clear, my lord. In another
Now
case,
it's
my lord,
closed.
I have, my lord, submitted.
It's a contempt jurisdiction now.
One wrong cannot be, my lord, continued. My lord, if,
It's a
my lord,
contempt jurisdiction now. Why didn't you file an appeal against that order?
I am not for now in the contempt petition, my lord, contempt proceeding, now in the review petition, my lord. That is why. In
Review
contempt
is
petition,
Review is disposed.
in contempt petition, my lord, we are helpless for that aspect.
Review petition is disposed.
My lord, disposed, but since IA has been filed, my lord, it has to be disposed of, my lord. Since, my lord, that clarification,
Yes,
at least.
My lord, yeah, my lord, lordship, kindly have a look, my lord. 3095, the present IA, my lord. What they wanted exactly, my lord. It's a very university, my lord, very tactfully they have written. I'm straight away coming to page 19, my lord. 3 specs they brought into, my lord. Firstly, in the instant application clarifies suitably the crucial approval spec with regards to the instant matter of the provision of section 44 of section 13, my lord. This very 13 was not born, my lord, in during my appointment time. It was not born. Suppose, my lord, this act has not been amended, they will not appoint over. They have appointed so many as like the petitioner. Then secondly, they said, my lord, to declare the financial competent inherent with the approval spec. Number 2, these are the internal matter, my lord. What they did before amendment, my lord, they can, my lord. thirdly, my lord, they said approval to be granted having taken zone of consideration of the service credential, meaning thereby, my lord, they want to reopen my writ petition. Over and above, they, my lord, the law which has been emphasized, my lord, in 2013.
My lord, may I interrupt, my lord? Only 1 minute. My lord, while granting approval, whether the authorities concerned, including Guwahati University or my lord, Finance Department or Education Department, would give a blind eye to the credentials of the petitioner. That continuation of wrong, my lord. One wrong cannot, my lord, two wrongs cannot make one right, my lord. Supreme Court is clear. If it has been, my lord, revealed later in later part, my lord,
What was passed in the 2019?
while granting approval, order was passed to grant time scale, my lord.
In the 2019 order. the time-
2019 as well as 2022. But whether Finance and Education Department would blindly grant approval, my lord, without going into the credentials of that very applicant, my lord, very candidate. If there is an illegality, my lord, it cannot be, my lord, condoned later on, my lord. Irregular appointment, it's all right,
Paragraph 7 is clear.
my lord.
Read it. Page 24.
Paragraph 7, my lord. Considering the submission of the learned counsel for the parties and on perusal of the materials on record, the writ petition is disposed of by directing the respondent authorities, more particularly respondent to register Guwahati University, to do the needful for granting time scale to the petitioner. It is, my lord, all right, my lord. It is all right with us. But subsequently, it has come to fore, my lord.
Read further on.
Time scale to the petitioner against a permanent vacancy in terms of the rule referred to above, which is framed by the university authorities themselves. The petitioner will also be entitled to get regular pay scale with effect from 11/1/2011. That is the date of her initial appointment as assistant teacher, as had been given to others.
And
So, my lord,
para 5, the last para.
my lord, that very page, my lord, page 25,
24. Para 5.
para 5. The relevant portion of the
learned counsel for the respondent.
for the respondent submit that the case of the petitioner can be examined by the authorities, and if it is found that the petitioner is entitled to be placed in the time scale against permanent vacancy as claimed by her, there would not be any difficulty in appointing her against a permanent post as per her eligibility. Everything is, my lord, all right for us, my lord. We agreed upon that, those aspects, my lord. We, my lord, only, my lord, taking your lordship to one aspect, my lord. If there is an illegality, if it comes into fore later in later stage, then what would this honorable court, my lord, direct? Whether, that is why, my lord, whether on that approval aspect, the state government will blindly, my lord, give approval, my lord, without checking into the credentials, my lord.
And we are trying to open everything that is now closed.
But it is clear, my lord, after
On your submission that you will have a look whether the petitioner is entitled to get the time scale. That's
Miller.
what you said. This is
Miller.
recorded in the judgment. After that, this court passed the order that the petitioner shall be entitled to so and so, so and so. Correct.
Miller.
At that point of time, did you raise the issue before the court?
No, my lord, we have not.
Petitioner was
My lord, that is clear, my lord. We have not raised those, my lord, aspects at the time of review petition, proceedings of review petition or writ petition.
Yeah.
But in the later stage, it has come to light that while she was appointed, her mother was serving.
You could have filed an appeal against.
No, my lord, at that time, my lord, while passing that review order, at that time, my lord, we were ignorant about it, my lord. So, my lord, but in the later stage, it has come to light, my lord. My, my lord, paragraph 1 and 2 of our representation, my lord. Page 40 and 40 onwards, my lord. And Supreme Court in several judgments clear, the irregularity can be cured But if it is an illegality, she was appointed illegally, my lord. After 10 years from the demise of her father, and while her mother was working. Those two aspects have come into light in later stage. my lord.
After filing.
So, my lord, now if the approval is a empty formality, my lord, then blindly, my lord, the state government can, without considering those aspects, my lord, grant the financial, my lord, we don't have any objection, my lord. Then.
My lord will see what is section 44, my lord. They have reproduced at page 8, my lord. For a moment, my lord. The university shall establish and maintain teaching, non-teaching staff ratio 1 point so and so presently. In order to establish the teaching, non-teaching ratio, university shall not appoint any teaching employee or fresh, meaning thereby after that shall not appoint. And why they are, my lord, acting as a agent of some finance department? What they have done it before amendment, my
My
lord.
lord, I am objecting to that word agent, my lord.
My
That
lord,
agent
university,
word
I am
should
not
be, my
saying
lord, expunged,
personal
my lord.
capacity. I am saying about, my lord,
You are not
university.
agents, my lord.
A university is saying, my lord, this burden, that burden will come. What they did, my lord, prior to amendment, the burden has been given by finance, or finance department was not there. That apart, my lord, lordship will see, my lord, if they are aggrieved, my lord, they could have challenged by way of writ petition also, or by a higher authority also, page 39. They have not challenged.
Uh,
My lord,
higher education.
my lord, one more line, my lord, I'll just clarify.
One minute. I'll hear you.
I'll,
Just clarify your letter. It is written by the higher education,
which letter? পঠাইছিলে যে
page 39.
9 Corinthians.
No.
Page 39.
Page 39 I have seen, lordship. I have seen. Clarification বিচাৰিছিল। এতিয়া ক'লে না যে 13 আগৰখিনি। Probably, lordship, when they have issued the letter, they have not gone through the actual position, lordship.
That's what I'm
After
saying.
going to actual position, they have not gone into
The
actual.
secondary education
if-
department who has the.
Lordship, actually, that school is, lordship, under the school education department. Lordship. Although he has signed as the higher education department, it should be school education department. Otherwise, lordship, as part of that one query was raised, lordship, whether miscellaneous application is applicable at this stage or not. In this regard, Honorable Supreme Court recently decided one cases, lordship, where the order is not implementable, lordship. If it is correctionable, then it is maintainable. If lordship, I can place 2-3 lines from that particular order. Lordship. I will play. Then I know. I will supply it, lordship. Otherwise, it was delivered on, lordship, 9 December 2024, lordship. In another cases by this month, lordship, 9 December. In one of the earlier judgment was referred by the Honorable Supreme Court in 2024 SCC online, lordship, SC 313, lordship, where the same issue was arise, lordship, whether in the dispose of petition or dispose of SLP, miscellaneous application is maintainable or not. Then the Honorable Supreme Court says that, lordship, a post-disposal application for modification and clarification of the order of disposal shall lie only in rare cases where the order passed by this court is executory in nature, and lordship, the direction to the court may become impossible to be implemented because of subsequent events or development, lordship. That is the, lordship, the ultimate dictum of the Honorable Appeal. And it was reiterated in the 9 December order. If lordship, I can place the relevant paragraph. Thus, this court made it abundantly clear that a miscellaneous application filed in disposal proceeding would be maintainable only for the purpose of correcting any clerical and arithmetical error. The court further clarified that a post-disposal application for modification or clarification of the order would lie
only in rare cases where the order passed by this court is executory in nature and direction of the court may have become impossible to the implement because of the subsequent events or development. Here, Lordship, after hearing the submission of the Council of the Guwahati University, it says that, Lordship, at the relevant point of time, they have not pointed out that when the direction for consideration was given by the Honorable Court, her mother was already in the, Lordship, that particular court. If one person is there, Lordship, there cannot be a compassionate appointment. It is a settled proposition of law, Lordship. And by that principles, Lordship, it will be, Lordship, correct. The correction order can be given by this Lordship. Otherwise, also, Lordship, if the interpretation is given, Lordship, the particular person was appointed in 2011, Lordship, and the rule itself says that the permanency will be given, Lordship, after 3 years, Lordship. If that part is counted down, Lordship, then it will be in 2014, then, Lordship, automatically that amendment of 2013 is came into force. So, Lordship may consider that aspect, Lordship. Otherwise, the law is very clear, Lordship. If Lordship go by that factual position, then it is a case of non-implementable. As because one person is in existence of a one person, there cannot be a, Lordship, the appointment of a compassionate appointment.
Is the matter still serving?
At the relevant point
At the relevant point of time, my lord. I don't know the present position, my lord. Yes. Illegal appointment, not irregular appointment.
Whether that appointment is illegal or irregular, I am not submitting.
I'm not going to.
I'm not.
Just check out whether the matter is still serving.
My lord. My lord,
Lordship, the judgment now, which I am relied, paragraph 16 and 17, Lordship. Paragraph 16 and 17. Paragraph 16 is about the earlier dictum of the Honorable Apex Court, Lordship, and paragraph 17, Lordship, that portion was reiterated, Lordship. My lord, may in paragraph 16, the Lordship emphasis supplied part, Lordship, a post of disposal 1, 2, 3, 4, 5, 6, 7, 8 from bottom 7 line, Lordship, that emphasis part, Lordship. A post disposal application, Lordship, for modification. And 17 is very clear that it was reiterated same part, Lordship. Ajay Kumar Jain. It was delivered not, Lordship, 9th of December, Lordship. So, Lordship, if it is impossible to act on the part, Lordship, then it is even it is a case is disposed of, even appeal disposed of, even SLP disposed of, Lordship, Lordship can exercise Lordship's jurisdiction, Lordship. There is no bar. That is my humble submission. Otherwise, Lordship, go by the facts, Lordship, then they have to fail to place the proper fact before this Honorable Court. Then, Lordship, it is a case of not implementable. Lordship can go by the dictum of the Honorable Apex Court. Lordship may maintainably part this application is maintainable. Regarding whether it is a, Lordship, illegal appointment or irregular appointment, I have no submission, Lordship. If go by the proposition of law, she was appointed in 2011 during the lifetime of her mother, Lordship, and the GU Act is came into force 2013 amendment. And if we go by the earlier act also, Lordship, then the permanency will occur after 3 years, Lordship. Then 11 plus 3, Lordship, it will become 14. It is after the, Lordship, that amendment period. So, Lordship may consider all the aspects. Oblige, Lordship.
So for my lord, I have relied, my lord, through judgment. Now, my lord, the core issue is that the new facts they came with, my lord, whether that can be acceptable or
I'm not. Only thing is now that you were appointed in 2011.
11.
And
law came in 2013.
no. If the 3 years is computed for your regular appointment,
That earlier law, my lord, we have to see. Check.
no, that's right. 2011. Then you will be in 2014.
14.
Correct. So 2014, the 2000 amendment came. 2013 amendment came.
My lord, shall not appoint a fresh, law says, my lord. If appointed
So shall not
after that, then only, my lord. 30 May,
13,
if appointed after 30 May 2013, then only my lord.
B, 44B.
My lord.
There's some conditional implication.
Implication is there, my lord. The law says, my lord, if appointed, they shall not appoint any person. If appointed, then only it will come. But my case is, I was appointed from that 11/2000. That aspect we need to be clear.
So you want approval from the government?
Approval from the government with the financial component. Regarding those credentials or not, my lord, it's their part, my lord. And since my lord, already this honorable court in the review petition has passed the order that section 44 is, my lord, applicable. So, my lord, that revisiting of that order would be in the appellate stage, not before this honorable court. If we agree with the submission of my learned friend, then it would be like revisiting the earlier order. That 2013 Amendment Act is not applicable. But in review order, it is clear, my lord, 2013 is applicable.
Same instance also, my lord, there is a Ganesham case, lordship is there. All lordship, can I have a look this copy, my lord? I have already marked.
I have it.
Lordship, kindly mark, my lord, 456. Having heard the learned senior counsel for the parties, having perused and relevant materials placed on record, we are of the considered view that present application is nothing else but an attempt to seek review of the judgment and order passed by the court on so-and-so 2021. That, my lord, true judgment, my lord, they cannot come if they are
Here is after the review order was passed.
disposed of.
The higher education or the school education department wrote that letter.
Right.
Saying that since it was you have appointed prior to the coming of 2013 amendment, you proceed and you comply with the court.
Basically,
So
communication
here-
between internal
here they're
communication.
coming, saying that in the event without in the review,
My
the
lord.
court has already given a clarification.
Hmm.
Para 5, I think. Para 5. Para 5.
5 and 6, both. Page 30, 29, 30.
Para 4 or 3.
No.
Para 3, 4, 5.
Page 30.
Miller.
The last 3 lines or the last 4 lines. Says this court would clarify that the university will accordingly seek the approval of the state government, so that the direction as mentioned in your reference to be giving Mr. approval. It's already in order.
So the court is not against that approval part.
Approval. It's order is there.
Approval part is there, my lord, but since it is
In
a
fact, my
matter
learned
between
friend has got-
internal, my lord, communications. And lordship will see, my lord, if it is so.
Basically,
In fact, my lord, the learned
this
friend,
is not the case. This is not the case where you should bring all this before the court. It is between you and the
department. Yes, my lord.
and you should clear it up within
Miller.
yourself.
I agree, my lord, that the department, the education department, finance department has got the discretion, my lord,
You can
to
solve it
approve
within yourself.
and to examine the credentials.
These are internal errors. Why should you bring this before the court?
Otherwise, if public gives some clarification, please clarify it with the role.
Yeah,
Lordship, before rising, my lord, I like to draw 1 minute time, my lord.
You can clarify it with the otherwise my skill budget is
Lordship,
Regarding examination of credentials, there is a discretion of the finance as well as education department. My lord,
Lordship will see for a moment, my lord, page 51, my lord. It is my learned brother has appeared, my lord, in my objection, my lord. Page 51 and 52, my lord. Roman 4, my lord. or I have reproduced the order of the contempt case, my lord. So and so heard, so and so for the respondent submits that the verification process was undertaken by the Guwahati University has completed and now shall proceed for the decision before the executive council. List the matter so and so which date the decision taken by the executive should immediately place before the court. In the event that the decision is not placed before the said court, he may call for the would be so and so. Then, my lord, order dated 23/24 in contempt proceeding, my lord. So and so learned counsel for the respondent submit that the process of regulating service in the petitioner complete and order in respect of would be passed in the week time. So and so is directed to place on the record. Then 9/4, my lord. So and so heard standing council university has placed the order a copy of the order dated 9/4/24 by which the petitioner has been granted time scale with so and so. Mr. Baruhia so and so limit submits that the order 9/4 is authorizing scale pay of the white vote, but it's not in consonance. Direction passed by the court, the violation of the same has been alleged in the present present. This spec matter would be considered on the next date of listing as so and so. It is, they said, my lord, before the court, till that time did not come. Now, my lord, the moment I filed the contempt, they came with a new place, which is not permissible.
Issue is you have also passed an order giving the petitioner time scale, isn't it?
Yeah.
my lord,
But not from the date of her appointment, but from the date of issuance of the order. Correct?
my lord,
On what basis have you given that order?
my lord, time scale,
On what basis have you issued that order?
my lord, the subsequent order, my lord. My lord, it is since, my lord, that 1:1.5 ratio is, my lord, as per section 44(1), my lord, 1:1.5 ratio is to be maintained. That is why, my lord, regular appointment was given 7 months back, my lord. And she is in the probationary period, my lord. It is in tune with section 44(1), my lord. That is why we have given her appointment, but she is still in probationary period.
9/4/2024 order,
Yes,
you have given her the time scale.
from, my lord, that day onwards, my lord. From 1st April 2024, my lord, she will get regular time scale, my lord. Not from 2011. 1:1.5 ratio. We are competent to, my lord, issue that appointment. But still, she is in the probationary period, so that credential aspect and other things, my lord, we can still, my lord, examine.
Yes, my lord, I have flagged mark. Provision period, though it is not required, only 12 months. I have flagged marked it, my lord, lordship can have a look. So for 3 years will come in the new case, not in this case.
Full act.
আসেনি
Yes.
ভলিউম
Volume 5. Look at like volume 5. Third edition, fourth edition, দুইটা। Section কেমন করে?
Which one? Which one?
Lordship will see the next page, my lord, 12 months.
Section কেমন কোন?
Next flag mark, my next flag. If it is applicable, my lord, in that case, no approval, nothing is required.
My lord, section, my lord, this is the Gothenburg state, old version.
আছে মোটা
This is the same one.
Section
1970, isn't it?
1947.
না এটাও আছে Lordship, can I have a look? Second copy আনতে লাগছে আপনার পাশে এটাও আছে
Everything boils down to that aspect. whether review.
No, Barbuya, whether it
Review
is,
order.
whether it is this act or that act, this court has passed a judgment.
Yes, my lord.
Yes.
They cannot come with a new IMI.
No, no, this court has passed a judgment.
Yes, yes,
And that judgment was reviewed
my lord. That
by
it is
making
final.
certain clarifications.
My lord.
This court is going to only say that in view of the clarifications made, you have to do like this.
Yes, yes.
That's all I can say.
My lord,
Because
for-
during the clarification is that the approval of the government is required.
my lord.
So that part only, and then I'm going to
No,
close
no,
the
approval does not require, my lord. They have wrongly, they have approached.
No, but
Notice.
Law does not say much.
no,
Court
Barbuya,
Lordship.
that review
There is an order. There is an order.
there
There
it
is a
says
note.
the government has the approval of government is required.
With a financial aspect.
My lord, so far this law is concerned, if I am governed, suppose, my lord, for the moment, lordship, there is no amendment. This law has been followed. In that case, my lord, what is the question of approval?
What do you heard during the review, when the review was heard?
My lord,
You were present.
I was not the council, somebody was there.
Council was present.
Yes.
Then, so on the basis of the review clarification, now I can correct a judicial order.
My
This
lord-
court cannot correct a judicial
My
order.
lord, yes, yes. It is only, my lord, submission, lordship, which read out
No,
at
no, no.
page 30, my
Your
lord.
lordship cannot review the review order.
This is not a submission.
My lord. It is the submission only, my lord, verify. Accordingly, basing of the submission of the respondent, then honorable court, then, my lord, accordingly it was directed.
Regarding it.
Will coordinate with each other for approval and appointment.
My lord.
There is there.
And they have appointed us, my lord, page 34, B10, my lord, in IA, without giving retrospective effect.
Yeah. That is a different issue now.
It is over and above, my lord, this IA is not maintainable. If IA is entertained, my lord, the several cases will come immediately after contempt. Several thousand many cases will be flooded by virtue of IA, showing the strength of this order if your lordship pass anything. Otherwise, this is not a maintainable matter.
Yeah.
Already
Okay.
order is there.
Heard Mr. PG Fukan. Leonard Standing Council, Guwahati University for the applicants. Stop. Also heard higher education. Huh? K. Gogol, Leonard Standing Council, Higher Education. For the response number 1 and 3. Finance. Mr. B. Gogol, Leonard Standing Council, appears for the finance department, appears for the response number 2. And Mr. J. Barbuya, Leonard Council, appears for the response number 4.
For writ petition.
Oblique writ petitioner. And secondary, Katania, and Mr. N.J. Katania, Leonard Standing Council, Secondary Education for the response number 3. Stop. The respondent number 4, oblique writ petitioner, initially filed a writ petition, which was registered as WBC 1421, oblique 2018. With a prayer for directing the respondent authorities to regularize the service of the petitioner against the existing vacancies and also for payment of
Regular time scale of payment.
regular time scale of pay in terms of what rule was it?
page 24, my lord, 23, 24.
No. What rule?
My lord, regarding compensated appointment as framed by Guwahati University.
In terms of para 3 of the rules framed by the Guwahati University with regard to compassionate
Compassionate
approach. This court, after hearing the parties, disposed of the said writ petition by order dated 8/11/2019, and the relevant portion is extracted here and below. Page 24. APA. Oh, 24 to 25. Stop. Draft para. Draft, comma. The applicants of the Guwahati University filed a review petition, which was registered as review petition number 35 of 2020, seeking a clarification with regard to the directions issued by this court in WBC number 1421/2018 on 8/11/2019, particularly with regard to paragraph 17. Stop. The said review petition was also disposed of by order dated 1/8/2022, clarifying that the secondary education department as well as the higher education department will coordinate with each other for approval and appointment of the petitioner as proposed by the Guwahati University. Stop. The relevant portion of the order dated 1/8/2022 is also extracted here and below. Page 30, B to B. Stop. Para. After comma. The Secretary to the Government of Assam, Higher Education Department. No, don't say like that, huh? Draft. They register Guwahati High Court. Guwahati University. By a communication dated 6/7/2024. An address to the Secretary to the Government of Assam, School of Higher Education Department. South special approval for granting time scale to the petitioner was appointed on compassionate grounds from the date of joining. Stop. The Secretary to the Government of Assam, Higher Education Department, by a communication dated 9/7/2024, wrote back to the register Guwahati University, and the relevant portion of the said communication is also extracted herein below. C to C, page 39. Stop. As the authorities in the Guwahati University is unable to implement the order passed by this court in view of the communication dated 9/7/2024, written by the Secretary to the Governor of Assam Higher Education Department. The present IA has been filed with the following prayers. Stop. With the following prayers. DDD, page 18 and 19. Stop. But after hearing the learned counsel for the parties, comma, this court is not in a position either to modify the order dated 8/11/2019, passed by a coordinate bench of this court in WC 1421/2009, as well as the order dated 1/8/2022, passed in review petition 35/2022. Stop. Accordingly, comma, it is only clarified, it is clarified that in view of the order dated 1/8/2022, passed by a coordinate bench of this court in review petition number 35/2022, 2020, comma, it is clarified that the secondary education department as well as the higher education department shall coordinate with each other for giving approval of the appointment of the petitioner as proposed by the Guwahati University. Stop. With the aforesaid clarifications, this IA stands disposed of.
My lord, in consultation with finance department.
I'm not saying anything. I'm not going. It is up to them. Whether do you have to do or not?
My lord,
There's no mention of finance department in the review.
my lord, in paragraph 5, my lord, there has been a mentioning, my lord.
Okay. Okay. For appointment of the petitioner proposed by the
In consultation with
the finance department.
4 and 5.
And in the contempt?
Contempt lordship fix the matter after some days only.
Okay. On request made by all the parties?
Well,
Okay, on request made by the parties. In
after
contempt,
vacation, well.
Huh?
After vacation.
Release the matter after the winter vacation. I'm not giving a date.
Lordship, that will do.
They
If
will take
necessary, we'll
some
make
time.
him mention.
Yeah, okay.
May I take back, my lord, those copies which I have supplied?
Yes.
My lord, regarding that, my lord, controversial credential part, my lord,
What?
that is, my lord,
Let them file appeal, my
my
lord.
lord, they are
Which
Right.
one?
the credential part of the
That this
practice.
court can't go in. And you did not do anything when the writ petition was heard. Now it's closed.
My lord. So, my lord, it's a. This,
You want to go for appeal, you go for appeal.
my
File
lord,
an appeal.
my lord, that at least that observation, my lord, regarding that credential aspect. my
No,
lord.
this court did not pass any orders with regard to the credential of the petitioner in
Yeah.
the writ petition. Now I cannot go into that. I cannot rectify judicial order passed by a coordinate bench of this court.
Since, my lord, it has been placed before this honorable court, my lord.
That's why this court has made it plain and clear that I'm not going into it. You want to file an appeal, file an appeal. It's up to you.
And
But
possibly,
even
my lord,
if you file an appeal, you should remember that there is a recording by this court that you look into the matter and see whether the petitioner would be entitled for time scale.
whether the my lord, that approval aspect, whether that will be, my lord, without considering the credentials, my lord.
That I'm not saying anything. Let them do whatever they want to do.
Their discussion, my lord. Whether that credential would be examined by the finance or education department, it is their discussion, my lord.
I'm not saying anything.
But
7.
Look,
most of
this
life,
is an IA, is a very thin line I'm going on.
my lord. Most of life.
Go ahead. You're representing the health department.
Yes, yes. And today I've been told, because I've checked all the orders. Actually, what we are required to, my lord, apply this code today. But my learned friend has today, my lord, informed me that there are, my lord, two lists. One, my lord, one of the initial, my lord, advertisement, where they were selected and they were sent to a medical board, where they were found to be not fit
Not
for this
fit.
particular category. Subsequent, my lord, similar persons, my lord, they
Same, not
participated in-
similar, same persons.
same persons,
same
not the
persons.
petitioners, but some other persons who were there in the earlier selection, who were found to be not fit, again participated.
No. I'll tell you. There was
Petitioner.
there was an advertisement.
Yeah.
Petitioners applied.
Yes.
They were selected, and then given what you call provisional
Appointment.
what you call it's not coming. Provisional allotments, seat allotments, correct? And then they were asked to go for a medical test, second medical test, PWD candidates. There they were found not eligible. So they approached this court.
Yeah.
When this writ petition was pending, there was another advertisement. This set of petitioners, 28 of them, 29 of them, they appeared in that advertisement. They went through the same process, went through the same selection, medical test again. They were found selected, they were found fit.
Lordship. So, my lord, out of the petitioners, my lord, about 100 and something.
I know.
29 has been now appointed.
They have given the list.
Yes.
Oh, that day you were not there, no?
Yes, actually, my lord, I don't have that.
That
I
list
can
was
have that
given from their
instruction.
side.
Huh?
Their side list was given, 29.
Oh.
From the side of the. government. Huh? So, my lord, on that point, I can clarify, my lord, if 3 days is given to me. Today, I came to know there is this particular issue that you are required to apply on this particular point.
Okay.
The same batch of persons, my lord, one by the same, my lord, authority, by the medical board. So that part I will have the instruction. Why the disparity? My lord?
Okay.
And,
When?
now, my lord, if not inconvenient on Wednesday or on Thursday.
Next week is a motion week.
Is a motion week.
But
Before vacation, it would have been better, man. The matter was hard.
I can have the instruction because otherwise, my lord, there is nothing to argue. Only I will have to, my lord, apply this code, my lord, why this disparity happened. You will have to point out to the authorities also that this has happened. They will have to.
no, since Chief Justice has declared as a motion week next week, I don't know if you're willing. If you're willing, we can. We can
On
make-
9th, my lord, immediately on the reopening.
When?
9th of January. If possible, my lord.
The whole
Subject-
matter will have to be hard again in that case. That should be avoided because time and energy given already. Let that not go waste. And that is why we say, because
on 3rd, my lord, on the immediately on reopening. On Thursday, my lord, in that case, Thursday I can see. Lordship.
no, well, again there will be Bihu vacation, all that is there.
Thursday, my lord.
So,
Coming Thursday.
এতিয়া এসপ্তাহত লোৱা
19, my lord, I leave it to your lordship, my lord. 19 or 18, my lord.
আজি কি তাৰিখ আজি কি তাৰিখে Let it be on 18th, my lord. No issue. Motion day even.
That's why I say I'll leave it to your lordship on 18th or 19th or my lord on 3rd.
Or 17th.
It's up to you.
17th.
Up to the parties.
আজি 12 তাৰিখে 13, 14, 15, 16, 17 ঠিক আছে ঠিক আছে 19
You
তাৰিখ
have not filed your affidavit also, no?
Yeah, that I can, my lord, I will have to file, I suppose.
Let them bring it in form of an affidavit, whatever they get.
That's why.
That will be on record.
Then on 3rd, my lord, not inconvenient.
Okay, heard Mr. K.K. Mandal, the senior counsel, assisted by MS and
Third January.
Stop.
ইমান পটকে
Mr. B. Gogoi, Leonard Standing Council, Health Department. Praise for
ক'ত গ'ল সেইখন
2 weeks time to file an affidavit. To file counter affidavit. Praise allowed. List on.
Lordship on 7, my lord, by 3rd I will file the affidavit. On 7, my lord, lordship may take up. In between they can reply.
7th.
7th.
Since it has gone to the
7th.
Yes.
first new year,
New Year.
let it be on 7th.
7th.
Yes. And Lordship may record that they will
Yes.
file it before on or before 3rd.
Yes, yes. That, yeah.
The authorities in the health department shall file the affidavit on or before 3rd of January 2025. Huh? And after that, list the matter on service.
Yes. As part of that. It will come as part of bill. Apply.
18 hearing.
May I please, in this matter, my lord, they took time to produce some record. It was, my lord, on 21st of September 2023, my lord. Court's order is there, my lord. And the records were sought for. And thereafter on 22nd 9 2023, by that also. Thereafter of.
You have the records.
Lordship, no, Lordship, we do not have the records, but Lordship, in this matter, Lordship, Mr. K. Gogoi will appear, Lordship. Today, there is some difficulty on his part. Otherwise, we have filed our affidavit.
Wow.
It is very clear, Lordship. The detailed affidavit is there, Lordship. Can it be immediately after vacation on a hearing date, Lordship?
My lord,
Mr.
no issue. My only prayer is that since September 2023, my lord, matter is pending, and in the meantime, 4 times they took time.
Okay.
Now, once they file affidavit also, but if they want to file further affidavit, no issue, my lord, only
Okay, heard
the
Mr.
particular record.
PK
PK
Das,
Das, my lord.
Leonard Counsel for the petition. On request made on behalf of Mr. K. Gogoi, Leonard Standing Council Higher Education Department. I'll give a date then.
Yes, Lordship.
List the matter on 21st January 2025 in order to enable him to produce the records. Huh?
20. May I please, your lordship. Regarding selection of president, vice president of the school management development committee, that guideline is at page 25, lordships. Guideline dated 27th June 2016. Page 25, lordships. Regarding selection of president and vice president. And relevant portion, lordship will find page 18. Middle portion, lordships. Page 28, selection process of president and vice president of SMDC. May I read, lordship, that portion? The inspector of schools, after consultation with the principal, headmaster, and local people, will forward 2 names to the Director Secondary Education, Assam, for each president and vice president, with the recommendation of the Deputy Commissioner within a period of 30 days. After considering the names, Director Secondary Education, Assam will provide the list to the government with his comment for selecting single name after comparing data of both the candidates, and then government will approve the committee. The other terms and conditions, including grounds of dissolution of assembly, shall remain the same as mentioned in the government notification number so and so so and so. The director of secondary education, the inspector of school principals, headmasters are hereby requested to complete the process. In terms of notification dated lordships, another modified notification was issued, that is page 32. Here is the director was the instruction to give appointment to the person concerned regarding selection of president and vice president. Then it was modified by another notification, that is page 32. That power has been entrusted to the deputy commissioner, page 32. That is dated 27th October 2021. Numbers so and so, got it? Numbers so and so. In partial modification of the guidelines for constitution of the School Management and Development Committee issued by government notification number so and so, dated earlier one, lordship, and letter number so and so so and so. The deputy commissioner is hereby empowered to select the president and vice president of the School Management and Development Committee of an education institution of the concerned district with the approval of the guardian minister. That lordship, note, take note, lordship, with the approval of the guardian minister, deputy commissioner was empowered. Earlier power was the director. In terms of this notification, lordship, IS instructed the headmistress of the school, page 37. Page 37, by letter issued by the inspector of schools, Kamrup District Circle, that is dated 30th September 2021. All the head of the institutions regarding submission of list of president, vice president for reconstitution SMDC, reference that earlier notification lordship, reference of letter number so and so 27/9/2021. With reference of this, I have the honor to request you to submit 2 names for each president and vice president as per prescribed format and as per guidelines contained in the notification enclosed herewith communicated by notification number so and so 27/6/2016 for a reconstitution of School Management and Development Committee to the office of the undersigned in the hard copy owner viewers. In terms of notification, lordship, HM called a meeting on 3/10/2021. 2 persons each for president and vice president has been selected. That is page 38. Page 38, lordship. Purpose for selection of president and vice president of the School Management Development Committee. A meeting of LOG Hindi High School was held today on 3/10/2021 at about 11 a.m. This meeting was called by the headmistress, Srimati Maladas, for the formation of new management committee of the school. The local people of the school are invited to this meeting. The people whose names are selected for the post of president and vice president by the local alert people are as follows.
What is LOG?
LOG is school's name, lordships. Full name, yes.
Okay, the name of the school.
Name of the school, lordship. LOG Hindi High School. Then 2 persons names actually for, that is HM forward the names of 2 persons, that is page 42. Two persons each by letter the 4/10/2021 to the inspector of schools, Kamrup Metro District Circle. Submission list of president, vice president for reconstitution SMDC. By refer next page, lordship will find names of the persons, 2 each for president, vice president, page 43. Devanand Singh and Pramod Kumar Jha for the post of president, and Nawal Kumar Jha and Pramod Kumar Tiwari for the vice president. Then thereafter, IS wrote another letter to the headmistress of the school, that is page 44. That is dated 11th of October 2021 to submit the names of 4 persons each directing. Submission list of lordship, the letter written by the inspector school to the headmistress of all the institutions. This reference office letter number so and so. In enclosing here with a copy of the letter received from the Director of Secondary Education Assam, communicated by letter numbers so and so 6/10/2021. I have the honor to state that, as informed by the Director of Secondary Education Assam, that it has been resolved to obtain the name of 4 persons instead of 2 persons for selecting a president and vice president for constitution of the School Management and Development Committee. You are therefore requested to submit panel list of 4 persons for each president and vice president of the SMDC as per prescribed format and acceptance format within 19 positively without fail. Accordingly, 4 persons' names is forwarded, that is page 45. This is the letter issued by the headmisters of the schools to the inspector of schools. Next, page 46, 4 persons each for president, vice president has been forwarded. What happened after that? Suddenly came to a letter lordship issued by the inspector of schools. That is page impugn order 47. 2 persons name entered in the president. Those are not selected by the authority, by the local people as well as the school committee. That was I challenge. That is letter was issued in terms of letter, minister's letters lordship. That cannot be. Inspector cannot communicate. But here the appointing authority is the deputy commissioner. But here is the communication is issued by the inspector of schools in terms of letter issued by the minister. That is letter lordship will find appointing authority is the deputy commissioner, not minister lordship. Minister is the approval. Here on terms of this letter number shows that M Minister T Transport.
Where is that?
That reference letter lordship short form written. Industries and Commerce Seed so and so data 7. In terms of this letter, inspector of schools forwarded to the lordships. May I read the contents? With reference to the subject cited above, I am pleased to furnish the following president and vice president for your school under the power conferred by notification number 27/6/2016. First notification, lordship. The names of president and vice president has the approval of the guardian minister under the power conferred by Government of Assam Secondary Education Department, Dispur, Guwahati's notification number so dated 27/10/2021. You are therefore requested to convene the first meeting of the SMDC within 3 days from the date of receipt of this letter to select 5 parent members to the SMDC under chairmanship of the approved president and SMDC, and also requested to constitute 2 subcommittee in president in the prescribed format in annexure so and so. Please note that the parent members are to selected to the SMDC are to selected by the 2/3 majorities of the guardians present the meeting. Bottom's lordship will find 2 names that's never forwarded. That is in violation of the notification, both notifications. Thus, the present petitioners they were selected. They approved. They initially requested headmaster to clarify, but it was not clarified by the inspector of school. Similar matter lordships already been decided in WBC number. WBC number 4776 of 2022. I am placing. Extra. WBC number 4776 of 2022. It was decided on 20th of July 2022. Paragraph number 5 lordship. Paragraph 4 lordship kindly be referring minister. A perusal of record could indicate that the OSD to Honorable Minister Transport, Industry and Commerce Department, Assam, directly wrote to the Inspector of Schools, Kamrup Metro District Circle on 7 June 2022 forwarding the approved list of names of President and Vice President of School Management and Development Committee of Government and Provincialized Higher Secondary Schools in respect of Kamrup Metro District. On the basis of the letter dated 7th June 2022, the Inspector of Schools, Kamrup Metro District Circle, issued the impugned communication dated 20th July 2022, directing the principal of Darapur Higher Secondary School for reconstitution of new SMDC. This court has perused the notification dated 27/10/2021 issued by the Principal's Secretary to the Government of Assam Secondary Education Department, where it is provided that in partial modification of the guidelines for constitution of SMDC issued by government notification dated 24/6/2016, the deputy commissioner is empowered to select the president and vice president of the SMDC of an educational institution of the concerned district with the approval of the Carrier Minister. A perusal of the records would clearly indicate that the steps taken by the official respondents were in contravention with the notification dated 27/10/2021. And thereafter, the Inspector of Schools wrote the impugned communication dated 20th July 2022. In that view of the matter, this court is of the considered opinion that the Inspector of Schools, Kamrup Metro District Circle, has no jurisdiction to write the communication dated 20th July 2022, by which the respondent number 6 was nominated as president of the said Darapur Higher Secondary School. Accordingly, the communication dated 20th July is set aside in court. The matter is now remanded to the Deputy Commissioner Kamrup Metro to initiate steps for selection of president and vice president, the new SMDC of Darapur Higher Secondary School, in accordance with the provisions of the notification dated 27/10/2021. While considering the matter, the Deputy Commissioner Kamrup Metro shall also consider the proposal dated so-and-so sent by the principal, Darapur Higher Secondary School, which has been done in accordance with the resolution and proposal taken in the general meeting of Darapur Higher Secondary School held on author. And similar order, lordships. Similar in one of the IA lordship, this court.
Okay. Okay.
Lordship. That is totally in violation. Lordship, to notification.
No affidavit has come.
They have not filed, nothing.
No, we have not filed any affidavit.
So you are conceding?
They are private as per also here, they have also, I think, they also not appeared.
Yes, it's in
In
the
spite of
hearing-
received notice, they
it's
did not
in
appear.
the hearing list.
Yes, sir. They received.
So you're
notice.
conceding?
Ultimately violated.
Similar order. I have seen the order relayed by my learned friend, my lord.
Violated.
Apparently, my lord, on the basis of the letter of the
Inspector.
minister, my lord, inspector of school may have proposed the other name, my lord.
And their names never been forwarded by the school committee and local people by resolution.
Yes.
Currently, my lord, the inspector of school has sent the new name instead of name proposed by the general body meeting, madam. On the basis of the letter received from the minister, madam. Case 48, my lord, where the headmistress of the school informed the inspector of schools that the name sent by school authority has not been approved, my lord.
Okay. We'll dispose it. Heard Mr. F.U. Barboyel and the council for the petition. Also heard Mr. N.J. Khatani, Leonard, standing council,
Secondary to
secondary education department. For the respondent,
my lord.
1, 2, and 4,
1, 2,
or 1, 2, 4,
4,
and
and
5.
5, my lord.
Stop. Deputy Commissioner, Mr. B. Dury, Learning Government Advocate, appears for the respond number 3. None appears for the respond number 6, 7, and 8, despite service of notice. Stop. Pankaj Chale. Who's respondent 6?
The principal of the school, madam.
Principal of the school.
Why her name in person?
Because
Headmistress.
he is a headmistress lordship is authority. He is also part of the authority. He
Headmistress
forwarded.
would have done her personal this thing was not required.
She has
No,
forwarded.
she forwarded letter lordship. Resolution forwarded.
In your favor. Correct.
Yes.
Yes.
In your favor.
But because
So-
she is a member secretary in the committee lordship. That's good.
Stop. Para. By this writ petition, the petitioners are challenging the communication dated 20 July 2022, written by the Inspector of Schools, Kamrup, within bracket M, District Circle, and addressed to the principal. Which principal is this?
LOG Hindi High School.
LOG Hindi High School.
Okay, don't say like that. Issued by the so and so. By which the respondent number 7 and 8 were nominated as 7 is president, is
Vice-
it? Were nominated as president
7 is president.
and vice president
8 is vice president.
of LOG Hindi High School. Stop. The communication further indicates that the names of the president and the vice president has the approval of the guardian minister under the power conferred by Government of Assam Secondary Education Department. Notification dated 27/10/2021. Stop. Para. It is the case of the petitioners that the that the Secretary to the Government of Assam, Secondary Education Department, has issued a notification dated 27/6/2016, which contains the guidelines for the selection process of President and Vice President of SMDC. Stop. The relevant portion is extracted here and below. A and B, page 28. A. Stop. The said notification dated 27 June 2016 was partially modified by notification dated 27th October 2021 issued by the Principal Secretary to the Government of Assam, Secondary Education Department, whereby the Deputy Commissioner was empowered to select the President and Vice President of the School Management and Development Committee, within bracket SMTC, of an educational institution of the concerned district with the approval of the Guardian Minister. Stop. Para. The Inspector of Schools, Kamrup, within bracket M, District Circle, by a communication dated 30 September 2021, requested all the heads of institutions of government and provincialized higher secondary senior secondary schools under Kamrup, within bracket M district, to submit 2 names for each president and vice president as per prescribed format and as per the guidelines contained in the notification dated 27/6/2016 for reconstitution of School Management and Development Committee. On or before 4/10/2021. Stop. What it is a general body meeting?
Yes, local people.
Para. What is written in Hindi?
In this translated lordship's relevant person, I guess.
This is a general meeting,
Sadhan Sabha, general meeting,
general body meeting.
general board meeting.
The general body meeting of the LOG Hindi High School.
Local, it would be local people, lordship. LOG Hindi High School, local people, along with local people, lordship.
Okay. Okay, then cancel it. The LOG Hindi High School accordingly had its general body meeting along with the local people.
Yes.
On 3/10/2021 and proposed the name of the
Lordship. Page 38 bottom, lordship middle was
one.
found. Page 38 mentioned their name.
And proposed the name of the petitioner number 1 and 2 for the post of president.
Yes.
And the petitioner number 3 and 4 for the post of vice president of the said LOG Hindi High School. Stop. The principal, the headmistress of the LOG Hindi High School accordingly forwarded their names to the Inspector of Schools, Kamrup within bracket Metro District Circle on 4/10/2021. Stop. However, the Inspector of Schools, Kamrup within bracket M District Circle, by another communication dated 11th October 2021, on the basis of a communication dated 6/10/2021, received from the Director of Secondary Education Assam, requested the heads of institutions of government and provincialized high school /HS senior secondary schools under Kamrup within bracket M district to submit panel list of 4 persons each for president and vice president of the SMDC as per schedule format and acceptance format by 19/10/2021. Stop. Accordingly, the headmistress of the LOG High School, Hindi High School, by a communication dated 19/10/2021, submitted 4 lists, 4 names for the post of president of the SMDC, including the name of the petitioners 1 and 2, and 4 names for the post of vice president, including the name of the petitioners 3 and 4, for in respect of the LOG Hindi High School. Stop. However, the Inspector of Schools, Kamrup M District Circle, by a communication dated 20 July 2022, furnished the names of the respondent number 7 and 8 for being nominated as the president and vice president, respectively, of the said LOG Hindi High School by stop. Being aggrieved, no, don't say that. Stop. Mr. F.U. Barbara, learned counsel for the petitioner, submits that the guidelines contained in a notification dated 27 June 2016 clearly provides that the Inspector of Schools, after consultation with the principal of headmaster and local people, will forward 2 names to the Director of Secondary Education Assam for President and Vice President, with the recommendation of the Deputy Commissioner within the period of 30 days. Stop. However, the said notification dated 27/6/2016 was modified by another notification dated 27th October 2021, whereby the Deputy Commissioner was empowered to select the president and vice president of the School Management and Development Committee with the approval of the Guardian Minister. Stop. He, however, submits, he accordingly submits that as per the guidelines, only 2 names each for the post of president and vice president was required to be sent up for being recommended for the post of president and vice president. Stop. However, by the said communication dated 20 July 2022, the Inspector of Schools furnished the names of the respondent 7 and 8 who were never recommended by the general body meeting, general body and the local bodies of the LOG Hindi High School. Stop. This being in clear contravention of the notification dated 27
26 to the 16,
2016
27,
and the notification dated
27 10
27
2021,
10
2021.
to 2021. The communication dated 20 July 2022 requires to be set aside and the respondents be directed to reconstitute the SMDC of the LOG Hindi High School in terms of the recommendation made by the general body and the local
Local
persons of the LOG Hindi High School. Stop. Para. This court has perused the notification dated 27/10/2021. No, 27/6/2016. As well as the has perused the notification dated 27/6/2016 and 27/10/2021. Stop. A perusal of the materials available on record would indicate that the steps taken by the official respondents were in contravention of the guidelines provided in the notifications dated 27/6/2016 and 27/10/2021. Stop. Who is the appointing authority?
Appointing authority is the now as per second notification Deputy Commissioner.
Deputy Commissioner. A reading of the notification dated 27/10/2021 clearly provides that it is the Deputy Commissioner who is empowered to select the president and vice president of the School Management and Development Committee with the approval of the Guardian Minister. Stop. Para. In that view of the matter, the communication dated 20 July 2022 written by the Inspector of Schools, Kamrup M District Circle. By which the respondent number 7 and 8 were nominated to be the president and vice president respectively of the LOG Hindi High School is set aside and quashed. Stop. The matter is now remanded back to who's the deputy commissioner?
Respondent number 3.
To the deputy commissioner, Kamrup within bracket M oblique respondent number 3 to initiate steps for selection of the president and vice president of the new SMDC of the LOG Hindi High School in accordance with the provisions of the notification dated 27/6/2016 and 27/10/2021. Stop. While considering the matter, the respondent number 3 shall also consider the proposal sent by the principal of is it the principal or headmistress?
Principal plus
Sent by the
headmistress. So
sent by the headmistress of the LOG Hindi High School.
page 42.
Shall also consider the proposal dated 19/10/2021, correct?
Yes, first.
It
Yes,
has
first-
to be,
first one was
it has to be the second one.
Second one, 4 person each. Maybe.
19/10/2021. Sent by the principal, LOG Hindi High School. Which has been done in accordance with the resolution and proposal taken in the general meeting of the local persons of the, what area is this?
Fancy
Of
Bazar,
the-
Guwahati.
Of the LOG Hindi High School.
Yes, Lordship.
LOG Hindi High School. Held on
Held on 3/10 to the 21.
on 3/10/2021.
2021.
Stop. Let such exercise be taken and completed within a period of Katani
1
1 month from the date of receipt of a copy of the order of this court. With the above observations and directions, this petition is disposed of.
I am obliged.
Item 21. Yes.
This is a case for non-payment of salary matter. Of a lady teacher of Sohit Solkor High School, Bonda.
Here, my amount has already been sanctioned, my lord. I think petitioner has received also, my lord.
No instructions so far, my lord.
In fact, I have.
Let us-
It may be soon. September বলছেন sanction.
নাই তো মানুষজনে ফোন কৰি থাকে
পাইছে চাগে খবৰই লোৱা নাই চাগে
এতিয়া নোট ডাউন কৰি পেলাই হেৰি কৰিলে
চাগে আপোনালোকে ইনষ্ট্ৰাকশ্যন নল'ব আপুনি মই আপোনাক কৈছোঁ
নাই ডিছপ'জ কৰি দিলে হ'ল যদি আপুনি
নহয় আপোনাক কথা দিছে 20 নহয় নৱেম্বৰত কৈছে 28/11 কৈছে
কমিউনিকেশ্যনটো কোৰ্টত দি দিলে হ'ল
মই দিছোঁ 8,67,290.
You're claiming for how much?
8,67,292, man.
The same amount has been sanctioned, my lord.
Sanctioned.
On 28,
According to him, man.
28/11, my lord.
The lordship may dispose the matter according to instruction he has written. No, detail.
27/11/2024.
Yes, my lord.
এখনো তারিখ কোথায়?
Uh,
27
digitally sign no আসবে।
You want to take instructions and come back?
It can be disposed of in view of this order. Or I can obtain the instruction whatever way better man.
Because this has been sent only to the accountant general.
I can do it.
From there it will go to
Treasury.
treasury. That road. Sometimes there will be some turnings.
Hazardous, my lord.
Correct, Kogoy. So it's not, we should not be in a hurry to dispose cases. Just
My lord,
because your money
after
has been
vacation.
sanctioned. See, it comes into your account.
Hmm.
And once it's come into your account, then we can close the matter.
My lord, there is the better option.
Heard Mr. D.N. Bhattacharya, and counsel for the petitioner. Mr. N.G. Katanial, standing counsel,
Secondary education.
secondary education, has furnished a communication dated 28/11/2024, written by the
Joint Secretary.
Joint Secretary.
Joint Secretary to the Government of Assam, Department of School Education, and addressed to the Accountant General within bracket A&E, Assam, whereby sanction was conveyed for payment of rupees 8,67,292 for release of error salary of the petitioner with effect from 1/1/2013 to 28/2/2016. Stop. Para. Learned counsel for petitioner prays for some time to enable him to receive instructions. Prays allowed. List after 3 weeks. The communication dated 28/11/2024 is placed on record.
Matter of 8, my lord, 8 of January, my lord.
I said 3 weeks. It will come up if you can make your mention.